Yes, sir.
Yes, may I please, Your Lordship? The reference Your Lordship would find in order dated 29/10/2024.
The only thing is that the harmonization of
That's
three
correct. That's
provisions,
They can't be read in isolation. There has to be proper harmony.
three
They
black
are-
marks, whether it will automatically get effaced or elapsed after a particular time, or it will
It will remain.
continue. So
Right.
this always.
The rule provides it would permanently remain because Your Lordship knows this is basically to enforce discipline in a police force. Because if somebody becomes errant or unruly or Milord acts, that is the provision which is contemplated in Rule 824. You may I place Milord certain provisions of the police manual. Your Lordship may kindly turn to 824. That is how they have Milord interpreting this note appended to Rule 832.
Who is for the other side?
Eight 24, Your Lordship may kindly tell. 824. Milord, this whole chapter 25 of the police manual rules
Yes.
that deals with departmental punishments. Description of departmental punishments, Your Lordship would find it in clause F, black mark or marks.
Black
Black-
marks or marks?
Yes, Milord. Black mark or marks.
Correct. F.
Yes. So it is punishment. Your Lordship may kindly turn to 832 now.
Is there any distinction between a major punishment and a minor punishment?
That is there, Milord, below that. Milord, the proviso
Okay.
provided that the punishments mentioned in clauses I to M,
Clauses
I small I
to M,
to small
I to
m,
M. Yes.
shall not be imposed on any officer. This, Milord, the second para, punishments mentioned in clauses A to H are classed as major and the rest are minor. Milord, two lines.
Okay. Yes. Yes.
Let's it may now turn to 832, Milord. Milord, here is the trouble. They have interpreted this note in a way and read into the provision which is not there.
My brother has pointed out that in the first proviso, you will find I to M.
M is not.
Where is M?
There is no M.
There is no M.
I too,
It ends with L.
that would be
See, A to,
KKL.
yes.
M
A to
can-
L
Maybe
is
a
M.
typographical error, Milord.
A to H is major and I to M as the
No,
proviso
maybe
says
that is AL, Milord.
minor.
Your Lordship is correct, Milord. M may not be there. I will verify. If there is a typographical error or any other punishment, Milord, we are not concerned with that, but I will still verify. Lordship is correct. I am right.
Yes.
Justice Raman is very meticulous that way
Yes.
because
Oh, doubt.
I'm sorry.
We
So-
find,
No, I am grateful. I will
we
verify.
find errors in the brief.
No, no,
find
that's
error
correct.
in the book.
That's correct.
That's the
That is correct. A penny also, Milord, matters.
Because of old habits. Old habits die.
Lordship deals with a branch where a penny also matters. So therefore is. So Milord, your Lordship may kindly turn to 832 now. Orders of reduction. So, every order, Milord, may I read? Every order reducing an officer to a lower rank or to lower stage in his time scale or withholding an increment shall state the period for which it shall be effective and whether on restoration it shall operate to postpone future increments, and if so, to what extent. Service Code Rule 82, in cases of exceptionally grave wrongdoings, an officer may be permanently reduced to a lower rank, but such service punishment must be explicitly justified and rarely resorted to, as all incentives to future good work are removed. Every order to reduction or forfeiture or withholding of increment shall set forth the pecuniary penalty entailed. Let the note neither 832A refers to black mark, it refers to some other punishment, like a lower rank,
Reduction in
a
the mark.
reduction yes, to a lower rank, to a lower stage, or withholding an increment.
Correct.
They are the classification of the punishments to which the note refers to. It doesn't refer to certainly the black mark. So here is the trouble. They have taken two lines from the note appended to 832A and will not conclude that it doesn't remain permanently. That is what they have read into the provision which is not there. And it doesn't have any connection with 824.
Now suppose if the note is appended to a statutory provisions.
Right.
Does it not partake a character of a statutory?
Absolutely. I'm not, that is
the
not
note-
submission.
Note or explanation or a proviso. These are the
Lordship is
three
correct.
modes. These are the three modes which are really used.
That is a part of the statute.
Part
It's
of
a substantive provision, yes, because that is the, in case there is an ambiguity or an explanation or a note, etc. is appended. So that is, it is a part of that, but it doesn't refer to black mark. Your Lordship may read the note. In giving effect to an order of punishment, care must be taken to prevent the officer being double punished, as would happen if he became entitled to promotion during the period of reduction and lost the benefit of this entirely in consequence of the reduction. That refers to certainly 832A. It can't be interpreted in some other manner. Let this, may I read it again? In giving effect to an order of punishment, yes, let's exercise. During the period of reduction and lost the benefit of this entirely in consequence of the reduction. When an increment falls due within the period or reduction considered necessary, the order should be one forfeiture of last increment up to the date when the next increment falls due, and thereafter forfeiture of both the last and next increments for an appropriately shorter period than would have been the case had the next increment not become due. But it doesn't have any correlation with the 824, this clause. If F. So, your Lordship may now kindly turn to 837. Two other also, may I draw your Lordship's attention. 834, black marks. Imposition of black marks. Black marks may be awarded alone. Now, this is an independent provision, or in addition to other punishments enumerated in Rule 824, except dismissal or removal to all officers of and below the rank of inspector. Up to the rank of inspector, this is an independent punishment of 824. No more than one black mark shall be awarded, or any one offense, that may be for any one offense. Yes. There may be another typographical error here. Awarded for any one offense except when moral turpitude can reasonably be informed. 3 black marks shall ordinarily entail reduction or forfeiture or withholding of an increment, the period of which shall be specified in the order, and after the period is over, the officer will be restored to his former position. Such reduction or forfeiture or withholding of increment shall not carry any black mark value. Again, he is restored after the expiry of that period. So this is a type of warning to an errant officer who does not or fails to carry out or discharge the duties cast upon a disciplined force. So this is independent. So 834 and 824 they operate in different fields. There is no overlapping. So therefore
834, what you are repeating, is reduced down to a minor penalty then.
Here
But 824 says
no, black mark will remain permanent. That is what I am coming to that. In addition to any penalty, it can be awarded. Now, that is what the language of the rule is. black marks may be awarded alone or in addition to other punishments enumerated in Rule 84. But this is an addition, not in derogation. 824 operate in a different field. There are different categories of penalties prescribed that has to be adhered to following the procedure in which it is to be contemplated. But
It is-
834.
But it is also in corroboration of a period to be specified in order.
That's correct.
If suppose if there is no period specified
Yes.
and the 3 black marks have been awarded without specifying the
No,
period.
not may not alone. At a time, it may not be. It is only
The-
one.
It talks about awarded, it should be awarded,
Alone,
no, first says black
Yes.
marks may be awarded alone
alone.
or in addition.
Yes.
So once the disjunctive word is used in between,
Right.
so the alone or in addition, both either of these situations may happen.
May happen. May happen. Lordship is correct.
And suppose if it is an alone situation where only
Yes.
the black marks are awarded
Absolutely.
without any further addition
Right.
of another punishment,
Right.
then what would be
Then, my lord, the consequence is there.
would be
Yes,
what would
the
be effect?
consequence.
Suppose if the period is not specified.
It is there. My lord. No,
Come to
not
me.
more than one black mark awarded for any one offense. My lord, for one offense, one black mark. Suppose there is one offense, it can be 2. But what would be the effect of 3 black marks that has been spelled out in several clause B of 834? Three black marks shall ordinarily entail reduction or forfeiture or withholding of an increment. The period of which shall be specified in the order, and after the period is over, the officer will be restored to his former position. My lord, he is being restored to his position after the specified. For that period, he is deprived of the benefits, etc.
It's true.
Yes.
So far as a plain and simple language as it's appear,
Right,
goes, there
right.
is no difficulty.
Right.
But there may be a considerable situations
Right.
where the period is not specified.
The expression shall be, it has to be.
If it is not prescribed
Black-
or specified.
No, my
then
lord,
what
black
would be the
mark is,
situation?
no, black mark will remain permanent. That I am coming to that provision.
That is
Your
what.
lord, yes.
Question.
My lord, general rules.
Sir.
My lord, 837. 35, 36, 37. No, your lordship may kindly come to 3 other provisions. All are to be read, my lord.
Shall be.
Yes, my lord, your lordship may read further. It is not over here.
Does it specify,
let
under
me-
does it
yes.
specify under the rule? What would be the period, maximum period or
No,
minimum
that
period?
will remain permanently. Once a black mark, that is a black mark. That will remain, that is the effect, my lord, I am reading 1-1.
No,
Your
no,
lordship,
when it says that period shall be specified in the order.
which shall
But
be
the
that
period,
is,
is there any guiding rule to fix the period minimum or maximum period? Or
No,
it is left to the discretion of the officer?
no, your lordship may, I am reading it, your lordship may, your lordship may read it further. 3 black marks shall, no, this black mark has no period. It will remain permanently. It doesn't have, I am coming to that. Your lordship may kindly read it further, my lord. All these 4 provisions are to be read together. The entire, my lord, from 834 to 837, they deal with the black mark. They deal with the black. Let me read one by one.
Oh, yes,
3
you
black marks
proceed.
shall ordinarily entail reduction or forfeiture or withholding of an increment. The period of which shall be specified in the order. And after the period is over, that is to be specified in the order. It is written, it is specified in the order. It may be for 1 year, 2 year, whatever. That is to be specified. That discretion has been given to the employer. Show order. And after the period is over, the officer shall be restored to his former position. Such reduction or forfeiture or withholding of increment shall not carry any black mark value. It shall be left to the discretion of the officer. Awarding the 3rd black mark to waive the penalty noted in clause B. In exercising this option, he shall consider the officers for which the previous black marks were awarded, the length of that has elapsed since they were awarded, any good service the defaulter may have to his credit. That is also appreciated, any good work in the Meantime, suppose he has improved, he has corrected himself. So therefore, that would also be taken into account while awarding the subsequent black mark. Then your lordship may come to 835, effect of black marks. The reduction or forfeiture or withholding of increment for specific offence shall carry the following black mark value. A reduction, etc., up to 6 months, 1 black mark. That is reduction up to 12 months, 2 black marks. It means a reduction for longer than 12 months, that is 3 black marks. So, effect of 9 black marks. That is why this remains permanently. Therefore, that has to be read with 836 and 837. So, that is the cumulative effect. 9 black marks shall entail reduction in rank or compulsory retirement or removal or dismissal. Whenever any member of the police below the rank of Deputy Superintendent of Police has been awarded 9 black marks, proceedings shall be run up against him with a view to awarding any of the above punishments. Any of the above punishments, Mr. has to be read with that. 824. So, general rules. Naturally, punishment has to be, the procedure has to be followed. General rules as to black marks. This is very important. Black marks shall remain permanently on record. So, there is no waiver. That would remain permanently on record and be taken into consideration in deciding the nature and extent of subsequent punishments, provided that the due allowances shall be paid for good service marks and any other recognition of good work on record in the delinquent's favor. So, the order awarding black marks shall specify the number of black marks outstanding against the delinquent, and when the imposition of 2 more black marks may result in reduction in rank or compulsory retirement or removal or a dismissal, or 1 more black mark may result in his reduction in the rank or loss of increment under these rules, the order shall contain a warning to that effect. It is an exhaustive provision. So therefore, it can't be read, this note cannot be read along with black mark. What the tribunal has heard in law, that they have read this note appended to 832 independently, construing that as if the black mark is a punishment separately.
Now there are 2 situations that
Man.
The situation 1 is
Yes.
that according to you, the black mark would remain perennial,
Right.
permanent
Right.
throughout his service career.
Right.
And the second situation comes
Right.
where the black mark will carry any value eternal.
Right.
What I find is that if you harmonize the provision section, I think rule 834 and 835.
Right.
If you look at 834, it says that when
Right.
there is a 3 black mark,
Right.
it may invite either the reduction in
Right.
rank,
Right.
forfeiture or withholding of any increment.
Right.
And then it says the moment this forfeiture or this thing is done,
Right.
then the black mark value will be effaced. It will efface all the black mark value. But black mark value you will find in 835, that how the black mark is to be valued.
Absolutely, Miller.
Correct. Now, when you harmonize 837, if the black mark remain, but it will not carry any value with it.
So therefore, 834 and 837 goes contrary. You say
No,
permanent
Millard, it is
and-
not contrary.
No,
No,
that's
no,
it.
let
It
me
has a
take
permanent
it.
value.
No,
It says
I'm sorry, Millard.
Right.
It is not contrary, Millard. Rather, it is in,
It.
but they complement each other. It is not contrary.
Please come to 834.
834, Millard.
B, 834.
3 black marks.
Last 2 lines.
Yes,
Bear in
no,
mind.
let's read it together. Such reduction or forfeiture or withholding of increment shall not carry any black mark value. Here, Millard, they avoid the double punishment. Let's have got it. That is what the intent is. So, Millard, suppose there is a reduction of rank. Millard, here, Millard, it says it can be done alone or it can be done in addition. Suppose there is already a punishment for reduction of rank, it will have no value. Suppose, Millard, it is not there. That is what Millard.
No, that probably I am not very clear.
No, you'll
in
assist
this
me.
regard.
I'll answer.
I am not very clear in this regard. What troubles or what comes in my mind is this,
Right.
because if you look at Rule 834, it's very clear that
Absolutely.
if it is a 3 black marks
Right.
given,
Right.
then it will entail either the reduction or a
Yes.
forfeiture or
Right.
withholding of an increment.
Absolutely.
And the moment it attracts
Right.
these three,
Right.
then it says that such a reduction, forfeiture, or the withholding
Right.
shall not carry any black mark value.
Sir,
That's the last sentence.
no, your lordship is correct. It doesn't
So-
carry. Absolutely.
And that means the moment either he suffered the
Yes.
reduction in rank,
Right.
or there is a withholding, or
Right.
there is a the forfeiture
Right.
of any increment,
Right,
then this black
absolutely.
mark value
Yes.
gets effaced.
Milord, I
Because
do agree. Yes, it goes.
it goes.
And nobody
Now,
dispute.
835, if you
Yes.
come to 835,
No,
it
that
says
is-
that for the purpose of reduction, one black mark will have this value, because it says a specific offense shall carry the following black mark value.
Yes.
For reduction, black marks will carry 1 point. For 12 months, 2. These are the values.
If the value erases,
If
effaces,
if the value goes,
effaces, then where is the question of
then
having a
you
permanent?
say 837 says black mark is permanent, it will remain.
Yes.
It says that and be taken into consideration in deciding the nature and extent of subsequent punishment. Means there, if it appears that there was a 3 black marks, let us hypothetically take an example. There was a 3 black marks that was inflicted upon a particular officer. That attracts either a reduction or a forfeiture or withholding. Automatically, as
Right.
per the provision of 834.
Right.
Suppose if there was a withholding of the increment,
Right.
how it is to be done? Because 835 comes into play,
Right.
and then the black mark values are being taken into account. If
Absolutely.
it is a longer than 12 months or a whatever, the reduction, if it is done. If the reduction is done, then it will have these values.
No, Milord, let me explain. Yes. There is. Yes.
Then what happens? The value is always an important factor for the purpose of inflicting or imposing the reduction in rank.
The-
Otherwise, 835 has no meaning.
The black mark value has a permanent feature. It doesn't evade. If harmonically you read
No,
334,
Milord, let
335 and
me, yes, I
337.
got your lordship's point. Let me explain.
And then if you come to these 837,
Yes.
then you say that this black mark shall remain permanently on record.
Yes.
No doubt about it. It will be only for ceremonial purpose. It will be there. It's
Right.
a record, black mark.
But
Right.
value goes.
But the value goes because if you say then be taken into consideration in deciding the nature and extent of subsequent punishment. Means if you want to subsequently punish him, say reduction,
No, Milord, your lordship.
can you take a value?
No. Black mark value refers to reduction, Milord. Here, your lordship may kindly read. Suppose.
Reduction is,
Yes.
I'm quite conscious. Suppose
Yes.
there is a reduction in rank.
Yes.
There is a reduction in rank.
Right.
Kindly consider. The 834 also talks about the
Right.
future conduct of the officer,
Absolutely.
and he can be restored to his former position.
Right.
Correct?
Right.
Hypothetically, let us see that he was holding the post of a senior constable,
Right.
and then there was a mark and he's reduced to a rank of a constable.
Right.
Let us see.
Right.
Then the conduct is later on, it becomes so good, then he is again restored to his former position.
Former position.
That's of a senior constable.
Lordship is.
Then he again committed something, and the black mark is also awarded to him. Let us see, the 3 black marks were there. Further black mark was awarded. 4.
Earlier black mark value has erased.
So
Completely.
now when it becomes 4.
No,
Then
Milord, that is.
837 says, 837, that black marks shall remain permanently on record. So
Absolutely.
3 black marks are already there on record. Let us hypothetically consider on record. And then it says, and be taken into consideration in deciding the nature and extent of subsequent punishment. Now, then if it is there on record and further one black mark is inflicted or two black marks are inflicted, then this whether this section says the 5 will be taken as a countable black marks.
Black marks.
5. And then if it is more than 3, again this provision of 834 will be attracted. 3 black marks may invite reduction.
Yes.
No, 3 black marks, may I read?
Then for doing again a reduction, reducing him to say in the rank of constable from the senior constable, then you have to give a value.
So that's the purpose for which this value has been
But
formulated.
why then say here that this value will not be there in clause 834 clause B?
Clause B. Last
Last
two
sentence.
lines.
No, that is in a
That is
different, let me explain. One more here. After the period is over, the officer will be restored to his former position.
Correct.
Read me
Yes,
further.
yes. Then
Such reduction or forfeiture or withholding of increment shall not carry any black mark value.
that means what?
The
That
value
if he is reduced in rank or reduction in rank, then this black mark for which the reduction is inflicted, the value of the black mark will go because you have said that value will be 835. It talks about the value of the black mark.
Every black mark carries some value. Once you utilize black mark and inflict penalty, if the penalty period goes, value erases.
And then 837 say black mark will be there. No doubt. It will be there in the record permanently. But what about the value?
See,
No, Millard, the
permanency of black marks and value of black marks are
Correct.
two different distinct things.
This is what I really want
the
to
black
express.
mark may be permanent, no problem. But how are you attaching value to it? Because
No, Millard, in
334
that
says
event, then
value
the
erases
punishment
after-
has also no meaning. If this punishment then has no meaning, the black mark will be redundant. So what for this? Then how it is to be? Millard, the black mark has an intent. Your Lordship has to
Then
go
we'll
to
have
the,
to go with
yes,
by the intention of the makers of
that's
the
correct.
legislation.
What is the, yes,
Now,
it has an intent. Black marks are not.
will I be wrong if I interpret in this way?
Right,
That these black marks are one of the major punishment
right,
under Rule 824.
right.
No difficulty. Reduction rank, withholding of an increment, forfeiture is also a major punishment.
Absolutely.
Now, what is happening is if there are 3 black marks, then one major punishment automatically gets converted
Right,
into another major punishment.
right,
There cannot be simultaneously because it is because of one major punishment, there is a conversion of another major punishment.
right,
The reason or the genesis of the another reason, the major punishment is the earlier major punishment. If both the punishments would remain
right,
simultaneously,
right.
then is it not jeopardizing his right?
No, Millard, the punishment I'm explaining. Millard, suppose for one delinquency, there may be one punishment. Suppose a subsequent delinquency is committed by the same officer.
That is what
There can be, Millard, it doesn't absolve the employee of being proceeded. He may be proceeded several times. There is no full stop to a disciplinary proceeding. It may be several occasions. So ultimately, Millard, he may not be, Millard, necessary for the establishment. We may dispense with his services. Therefore, Millard, this punishment of removal and dismissal. So, Millard, the basic intent of this black mark is to enforce discipline in a discipline force,
No doubt.
so that no police officer can go berserk or break the moral of the police force. So therefore, Millard, your Lordship has to
You are
go to the
absolutely
intent for which this is being provided. So that is,
Mr.
yes,
Advocate General, you are absolutely correct.
yes,
In a disciplined organization,
yes,
a very minor indiscipline
right,
that may invite a major punishment. There
Absolutely.
are katina of judgments of the Supreme Court or
Absolutely.
different high courts in a very uniform way.
yes,
But what we are really thinking about it, that when you have formulated a statutory rules,
Right.
and the statutory rules provides that how this punishment can be convicted or imposed upon the employee of a disciplined organization,
Right.
where you have introduced for the first time this black mark theory.
Not for the first time, it's since 1861, Millard.
Actually,
It's 150 years by now. Maybe more than that.
actually, I am
1860
not accustomed with that.
Is as per the Police Act. But this, it is by, it is a central act.
One more thing which is bothering
Yes.
is, come to.
It is not a new provision, Millard. It is, Millard, in the police manual rules since 1861. A tested law. I'll come back on this. This particular provision has to be read in isolation, not, Millard, sorry, together, not in isolation. Your Lordship may kindly see, the black mark carries a value. It cannot be valueless. So what is the meaning of then black mark? It is, Millard, a black mark is not awarded in vacuum. It is for a particular offense or a delinquency or a default or any kind of malfeasance committed by an indisciplined police officer. Millard, he can't go scot-free and claim that, no, notwithstanding the black mark, I'll still get the privileges of this. So it has to remain, and it has to remain with a value.
No, no, because these are the numbers, but they issue black market section of the which are police
I know your lordship's query, I'll answer.
What?
Let,
No, we are. in
No,
different,
no, we are on a, absolutely, we are going into a I
different
would say
area.
substratum of the sea or a
Right,
bedrock of the sea.
right.
When we are
But I'll
all
try to go
grappling.
there.
No,
I will also
we
try
interpret the
to.
rules subsequently.
when
I am
we
not a
we
scuba
we are
diver.
all grappling with this
Source.
I am not a
824.
scuba diver, but I will try to go there. I'll reach there.
No, there's no, there will not be any pressure,
Right.
water pressure on you.
Right,
There 824, 833, 835, 837, all we are trying to interpret it.
right.
These are coming from where? Is it a rules? It is a executive instruction, or it is a regulation, or what? Let us first go into that question, that what is the character of this?
So this is under the Police Act, Millard. This is,
Show us
no,
that
it is
under what?
from the very, your lordship may kindly.
if it is an executive instruction, for example, then we need not interpret it all.
No, Millard, your lordship
Show
may
me
kindly.
the
General
source of this so-called rules.
Section 12 of the Police Act,
Please
1860.
let us show us that what powers it has.
Section
So
4.
come to,
Millard, this is a
page-
colonial act. Your
Let
lordship,
us see.
if your
Let
lordship
us-
is holding this book of Whaler, then
Yes,
it would be at
yes,
page 589.
646.
yes.
Section
646.
46.
Right.
Section 12.
No, it may not be your lordship is holding a different book.
Anyway, section 12.
This is the same book. No.
Section 12 of the Police Act. No,
Correct.
maybe this is, I am holding a Whaler.
Yes.
Orissa laws.
That is
yes.
a costlier book.
Mr. Acharya, we got doubt because when you read chapter 25 under the heading departmental punishments, there one note is appended. Rules marked with an asterisk have been sanctioned under section 7 of Police Act 1861. So this book gives asterisk to 824. It doesn't mark asterisk 834, 835, 836 and 837. They are asterisk. So you have asked us to harmonize, which is not a rule, but it is in the book.
Which one?
820.
If it is not asterisk, so what it is? Why should we delve into that?
At the top, you will find the chapter, the head
Oh,
note.
your lordship is asking why this asterisk mark?
No,
They have been inserted on
No,
different.
Mr. Advocate General, it's not that. Why it is asterisk marks is very clear.
Right,
Section
If
7.
if you look at the
Right.
broader head, the
Right.
chapter 25,
right.
punishment, departmental punishment, then
Absolutely.
within the brackets,
Yes.
rules marked
Marked
with
with
the
asterisk have been sanctioned under section 7 of the, yes,
7 of this act.
yes.
And
Seven
these are the provisions which has come for interpretation
Right,
are marked as an asterisk.
right,
No difficulty.
absolutely,
So it is under section 7.
right.
Come to section 7, what is the rule making power? or
Appointment,
executive?
dismissal, etc.
Yes.
of inferior officers, subject to the provisions of Article 311 of the Constitution, and to such rules as the state government may from time to time make under this Act, the Inspector General, Deputy Inspector General, Assistant Inspectors General, and District Superintendents of Police may at any time dismiss, suspend, or reduce any police officer of the subordinate ranks whom they shall think remiss or neglect discharge of his duty or unfit for the same, or may award any one more of the following punishments to any police officer of the subordinate ranks who shall discharge his duty in a careless or negligent manner, or who by any act of his own shall render himself unfit for the discharge thereof, namely, fine to any amount not exceeding 1 month's pay, confinement to quarters for a term not exceeding 15 days, with or without punishment, drill, extra, guard, fatigue, or other duty, deprivation of good conduct pay, removal from any office function or personal emolument.
Specified, four categories.
Absolutely, my lord.
Where do you borrow the concept of black mark apart from this four?
My lord, that is 12, section 12.
No, you are extending beyond 4, you are extending 824 is an extension beyond 4, that 4 categories
And under section 7.
under section 7. Section 7 confines four penalties. You can't end by bringing a executive instruction.
No, no, what is written here, I have to check that. I don't know whether it is, no, that is, my lord, this book, I don't know, I have to go through
That
the
is why
ruling.
I tell you,
No, that's
Mr. Advocate
correct.
General,
You can't, my lord, what is the provision here? I can't, my lord, your lordship is interpreting why it is the asterisk, why it is not, why it is, that is not the.
Mr.
Let the rules are, yes,
The first impression which I had,
Right.
because I find from this book
right.
that on the top, it was
No,
written.
maybe, my lord, in which
Orissa
context
police
it
rules.
has been written, my
So
lord, I
I
have
was
to
under
check.
the impression that these are the part of the.
Maybe, my lord, but the rules, your lordship, my lord, in which provision, even if the wrong quoting a provision, did a rule. My lord,
No, no,
even,
no,
my lord,
no.
there are decisions I will say,
No.
wrong quoting of a provision does not invalidate a rule.
No definite.
That's correct.
Problem, no
So
problem.
rules, how it was framed, I have to check if your lordship is going to the validity of this rule, that is a separate chapter altogether. Here, my lord, that is not the issue. Issue is something else.
True.
It is not the validity which is under challenge. So, my lord, these
No,
minute
this-
details, yes, that's correct.
Probably, it's not that we are
That's
going to
correct.
struck down any
Right.
of the
That's
rules
correct.
to be
That's correct.
ultra virus or
Absolutely,
intra virus.
absolutely, my lord.
We are not going
I'm
into this.
so grateful.
What we are saying is
Yes.
now.
Lord, that is under
let
which
me
provision?
express my mind. My
Yes.
brother has also. What
Yes.
we are thinking is
Yes,
that we can definitely go into the nature of this.
right,
If we find that it is mere an executive instruction,
right, absolutely,
issued without any power having conferred under the parent statute or
Right.
under the subordinate legislation or a delegated legislation,
right,
then whether these executive instructions are a legally or invite a legally enforceable right. If it is not a legally enforceable right,
right.
then in that event, why we venture to go and interpret
It
those
will be-
provisions?
And the whole thing goes, your lordship is correct, the
We
whole
need
thing
not
goes.
interpret it all.
No,
This
you
is
are right,
why
your
we
lordship is
wanted
right.
to know first whether it is a mere executive instruction
Right,
or it has got any statutory flavor
right.
which really
Your lordship,
confer any
I have
legally
blood
enforceable
deeply
right.
obliged to that, deeply
That's what
obliged.
we are thinking
So
of.
there has to, your lordship is correct, absolutely correct.
There are many,
So that is the
there are
real,
many typos also.
no,
Just
that's
pick it
correct.
up.
Lord, these
And
books
keeping
also.
in mind only one judgment which is struck in my mind
Yes,
was that
yes.
there's a Nasli Wadia's
Nasli
judgment
Wadia.
of the Supreme Court, delivered justice B. Sinha.
Right,
There the same situation arose
Right.
in relation to another act.
right,
One instructions was issued
right.
by a ministry of the Home and Department.
Ministry of Home Affairs,
Yes.
yes,
They're saying that you should follow these principles
right,
while taking any action under that act.
right,
Then the matter went to, because everybody was taking advantage of that particular instructions. Then the matter went to the Supreme Court, and then the question arose whether that power was there on that particular ministry to issue such an instruction.
right.
And if it is an instruction, then it is merely an executive instruction. It does not really bestowed any
Yes.
any legally
Legal
enforceable
or
right.
enforceable right. Lordship is correct.
So that is why I was thinking in that way.
Lord, the whole thing, let me explain. Milord, maybe there is some doubt, let me clarify it. That
Yes.
824 and this 832 and 836, Milord, your Lordship, there is some, let me clarify it once again. There may be some, your Lordship may kindly again read it. Milord, this reduction in rank, your Lordship was reading 834 clause B. Your Lordship may read it again. Why it is said in this context, let me explain. Milord, black mark, your Lordship read 834A. That can be awarded.
834 being not asterisk. So that cannot form part of our domain. Why should we go into that? That is not asterisk. That is not marked asterisk. So that doesn't form part of that rules which you are referring to.
No,
That
no.
is not out of the purview of Odisha police rules which you are
No,
construing.
12 also confers power, my lord, rule making. That's
So
it is not.
834, from where 834 exists? Because of this asterisk, you see that chapter 25,
Right.
there is a bracket, note appended. Rules marked with an asterisk have been sanctioned under section 7 of
Has
the
been
Police Act.
sanctioned under.
Under
Yes.
Police Act,
Right.
1861.
Right.
So 834
No,
being not.
framed and sanctioned are two different things. Sanction and framing rules are framed under section 12. Yeah. So that's correct. No, your lordship may sanctioning and your lordship may kindly, therefore I am reading the whole, let the two sections be read. Section 12 of the Act, my lord, confers the power for rule making. Lordship may kindly, section 12. No, 34 is a part of the police manual rule. Can your lordship deduce that 834 is not a part of the OMR rules? It's not a part. Then the whole, book I have to throw me and to argue independent of this.
Because of that.
No, asterisk or no asterisk is not the issue. That is not the issue. Your lordship is segregating that part and is interpreting this in a different way.
Sir, because of that bracket.
No, bracket has nothing to do. Your lordship is interpreting it in a far different way. It's not the way, Milord. That's not the rules of interpretation. I'm sorry. That's not the rules of interpretation. 834 is to be segregated from the OMR rule. But I have to, if your lordship section 12 and section 7 are two, it is written sanction, have been sanctioned under section 7. So what is that?
Ultimately, what you say is the source is 12, not 7.
Yes.
7 is
Section
only
12, your lordship may read. Section 12. Power of Inspector General to make rules. The Inspector General may, from time to time, subject to the approval of the state government, frame such orders and rules as he shall deem expedient relative to the organization, classification, and distribution of the police force, the places at which the members of the force shall reside, and the particular services to be performed by them, their inspection, the description of arms. What is this? Accoutrements. What is this? I don't know this word also. And other necessaries to be furnished to them, the collecting and by them of intelligence information and all such other orders and rules relative to the police force as and all such other orders and rules relative to the police force as the Inspector General shall from time to time deem expedient from preventing abuse or negligence to duty and for rendering such force efficient in the discharge of his duties. This 834 comes under that. It can't be not said that this 834 is to be read independently. There are two different provisions. This Milord 84 may be a creature of section 12. So that can be asterisk, Milord. This is sanctioned under section 7 of the Act. That is say the subject to 311 because 311 cannot be overridden by the statutory rules. Article 3, that is why it says subject to 311.
Going at the top, last, whether there is any.
the approval.
Maybe sanction, Milord, is different. Source of power, Milord, is it in dispute that the government doesn't have the power to make this rule?
12 is the source.
can it be
And-
deduced that the government is bereft of any power to make the service rule?
Sanction is approval of the.
Milord, your lordship knows 309 is a separate provision and this police act is a different act. So that is again subject to 311(2). 311.
Mr. Acharya, Section 12 speaks of framing rules or issuing rules by the Inspector General.
Right.
Order, subject to state government's approval. So 834 being not asterisk.
May
it
not
has
be.
not. So that is what we are asking you.
That's correct.
whether
That may
has
be
got
ordered.
the-
It
the
doesn't
approval
mean
of
that
the-
this provision is
that has-
redundant.
Mr. Acharya, whether that has got the approval of the state government, we do not know because of not there being no
But
asterisk
it has
mark
to be,
there.
Lord, your lordship have to presume, let the other side say it is not approval of the state government. How can there be in the rule? It's a book, my lord, which has been
It is a
printed by
book.
an authorized bookseller,
it is a book.
publisher.
It is.
Now, let me produce the gazette. Let me produce the gazette.
Yes.
Yes, if your lordship has that doubt, let me produce the gazette. We are, my lord, how can that be doubted that 834 is not a part of the Weimar rule? I don't, my lord, I am asking myself. Even if it is not asterisk, my lord, can it give an effect to?
Sir,
I am asking myself, suppose it is not marked asterisk, can it not be given effect to?
so that is what the editor of this book has made it clear in that
Lord, editor of the book, I am sorry, is not the government. Editor of the
So
book
that is
has
what we are
just
asking. Sir,
reproduced the.
we are referring to a book.
No, maybe he is not the person to write the rule for the government. He is just reproducing whatever has been written in the gazetteer of the government.
So that
I
is why
will
we are
produce
asking
the-
you. That is why we are asking you.
No, my lord,
whether-
suppose I am asking myself, not a question posed to your lordship. I am sorry, I can't do that also. I know my limit. But suppose it is not marked asterisk. Can that 834 be treated as redundant or obsolete
Yes, subject
or
to-
not, my lord,
subject
existing
to
in
our
the statute?
Subject to our satisfaction that it passes section 12 necessary ingredient. Test is laid in section 12 of the Police Act. When
Of
you
course,
say
that is the
when you
power
say-
which has been
when-
conferred to the government.
Sir, when you say Rule 834 emanates from Police Act 1861, pursuant to Section 12, that has to be in consonance with Section 12.
Lord, this whole
which is to pass-
book, my lord,
Sir,
this whole police manual rules, my lord, it's 200, 150 years this force is working, my lord. This is not a new force nor a new rule that this government enacted. 150 years of service to the state, and my lord, your lordship would say that whether it is asterisk or non-asterisk, so therefore this is a redundant rule.
that is what we wanted to be clarified.
Lord, I will clarify that. Let your lordship, I will clarify that.
And give that Governments of India Act.
Well, let it come some other day. Why should I waste your lordship's time? There is also a division bench, so I will produce the
No, I
whole.
tell you very frankly, there are something which is really going behind as well, because these are the things which has really carried forward, or we have really elongated it after the independence was there. So there is a Delhi Police Act also, and where the power is also given to make a lot of the police rules. Everything is also there.
There's a different enactment.
But
Delhi
still
Police
has-
Establishment Act,
No, no.
CBI is a creature
No.
of that. No, that's a different enactment.
Delhi
It's a
Police
different-
Act is separate.
is a separate act, but there is certain powers which is also given.
Right.
Then we have to also look into the provision of the Government of India Act also before the constitution that was applicable.
It's a state subject. It's a state subject.
At that point of time, it was a Government of India Act. Britishers, they promulgated before the constitution came. Lot of
1935.
powers were there given.
That
And
is why the
because-
Delhi government is repeatedly demanding, give me police. I can't.
And then because of the
Yeah.
Article 13 also, we have
Right.
to think about it.
Right.
And the constitution has also borrowed those
Right.
provisions to
Right.
continue, provided it is not inconsistent with the
Right.
spirit of the constitution.
That is why, my lord, section 7 refers to 311.
That
Must
is
have been amended. You are
You know
what
absolutely
I was
What I
thinking, audits.
right.
Guwahati High Court judgment, you have seen that.
I am thinking in a broader, because we have to then
No, no,
find
you're
the
right.
answer from all these provisions, and then
Milord, personally speaking, I'm very liberal. I do not want a person should be subjected to double jeopardy. Very clear. My conscience is also clear. But the question is, these are all, Milord, rules which are to be very strictly interpreted. Navy, Army, Defense Force, this police force, these are all, Milord, disciplined and organized sectors of the, your lordship knows how difficult it is to maintain a police force. Very difficult. Not from my little experience within 7 must have come. So we have to enforce discipline. Any liberal interpretation of any provision, Milord, that would lead to an unruly situation.
Mr. Advocate General, I am very
Yes.
adopt a
There
very
can't be
lenient or a
interpretation.
lenient or a purposive
That's correct. That's correct.
interpretative tools.
Absolutely.
In interpreting those laws relatable to a disciplined organization.
Absolutely. If an army officer, Milord, says that he will be robbing and bursting the public,
Omitted while
no, your lordship is correct.
compiling the book.
Those books, Milord, I'm sorry, I'm not, Milord, anything personal. They carry lots of spelling mistakes, lots of things. I also at times wonder whether it is. So, your lordship, I don't know whether that would amount to.
Get the gadget so that
I'll get
things will get.
Milord, we have also published it in the government page. I'll
That's
produce
the better
it.
thing.
He says, Milord, any date convenient to my lords may fix.
Once something has stuck in the mind, it has to be
No,
erased.
clarified. Milord,
Has to be erased.
absolutely. Milord, I'm very clear on that. But one thing, it also disturbs me. If there are two punishments for the self-same offense, that is also, Milord, hit by 22, I am conscious of it. So therefore, there has to be a harmonious. They say that it is to be, Milord, I will clarify, come back to your lordship on this aspect. What is the...
Because it's another thing which I must be very because
Right.
I believe is a more transparent and fair way
Right.
of deciding a particular issue.
Right.
That it is better that the judges should also express
No,
their
of
mind.
course, of course.
What is
Milord,
really
that has
passing
to
through
be.
their mind to have a
Otherwise,
more
Milord,
clarification. What is troubling me is this, that discussing that 824 talks about the major punishments and the minor punishments.
Right.
A to H, according to the first proviso, says that these are major punishments.
Right.
This black mark is a major punishment because it comes within A to H.
Right.
The reduction in rank is also a major punishment coming within A to H.
Right.
Withholding is also a major punishment coming within A to
A to
H. When you say that these three black marks can be converted into a reduction
Right.
in rank, so you are substituting or converting one major punishment into another major punishment.
Right.
If you convert it, then why not the first will lose its existence because it is converted, it is infused, it loses its character and evolved a new character of reduction.
No,
How both can simultaneously run?
no,
because
it doesn't simultaneously exist.
No, black mark as such is not a penalty unless it culminated to
Milord,
some.
that is exactly what I was going to explain. Your lordship, once, Milord, let this last doubt, let it be clarified.
So
explain this particular question which you, Lordship, may I again read it? I'm sorry, at the cost of only one, because this doubt has to
Hey,
be
what
clear.
what is troubling us?
Let me answer.
No, no, let us understand what troubling us. Suppose you have 3 black marks. The black mark is converted to some penalty, reduction of this thing. And the value of that black mark has to go. If it has a permanent feature, these 3 black mark can be in future also you can utilize, and again you convert it to another penalty value.
Then you provide a value.
Then is it not a double jeopardy? The same black mark is being converted on the basis of its value, converted to different penalty at different point in time in the career. Then is it not a case of double jeopardy?
Let me interpret in this way. Your Lordship may suppose, my Lord, it's a clear interpretation. Let your Lordship please care. Let me explain. Let your Lordship please listen to me. Lord, 3 black marks that leads to imposition of a punishment. Clear, my Lord, under 834B.
B.
Black marks can be awarded alone or along with another punishment also. That 834A says, once, my Lord, due to 3 black marks, if there is a reduction of rank or, my Lord, increment, withholding of increment, or forfeiture of increment for a specified period, the moment this punishment, my Lord, comes to an end for a specified period that is to be specified, this black mark doesn't have any value. Your Lordship is absolutely correct. I bow down. But what about 835? 835 says, my Lord, the reduction or forfeiture of withholding of increment for specific offense that can be awarded independently under 824. That would carry the black mark value. They operate in different fields. Lordship is not. Reduction in rank owing to 3 black marks and black mark value owing to reduction are 2 different things. Suppose, my Lord, suppose somebody, yes, my Lord, that is what it says.
Let us,
The reduction.
then let what you are saying is
No, Lordship,
very interesting, and
no,
there may
that
be a
is-
situation. Let us understand in a more
Right.
hypothetical example way.
right,
Suppose a officer is punished with a
black marks.
3 black marks.
Right,
There are 2 things that may come. Either 3 black marks are imposed alone,
right,
nothing, or 3 black marks can be imposed with withholding or forfeiture of certain increments,
right,
or addition.
right,
It can be done
right,
both ways.
right,
Say the first example, only 3 black marks.
right,
Then the subsequent section says that if there is a 3 black marks,
right,
it may invite a further punishment.
right,
So what punishment is another provision which says reduction in rank.
right,
And for the purpose of reduction in rank, there are 3 situations.
right,
And then the value is also given to these 3 marks for each situation.
right,
Where up to 6 months or where up to 12 months or 12, 1,
Right.
2, 3. These are the values of the black marks. No difficulty.
right,
This value is given and he is inflicted by a punishment of reduction in rank.
right,
No difficulty.
right,
The section says the moment it is converted into a reduction in rank,
right,
then it will lose its value. The sentence is there, then it will not carry any black mark value.
But provided this black must result in
Into a
reduction.
reduction.
That's correct.
That is what I'm saying. There are
Right.
2 situations. That's
Right.
right. So the moment this black mark is resulted or culminated into a reduction,
Right,
then this black mark will lose its value.
right,
No difficulty.
right,
Then subsequent provision says that the black mark would remain permanent. It will remain permanent.
Milord, that is a, that
It
is.
will not go.
No, that will not go.
Correct.
It has to
Now,
remain.
now the question is, suppose if it remains,
Yes,
then 3 black marks has also already resulted into a reduction.
Just
You have already utilized these 3
Very
black
well.
marks and reduced, he inflicted a punishment of reduction in rank. Now suppose later on, again there is another black mark. Then it will be a fourth black mark.
Will you utilize
If it-
the earlier three?
Then you will say now it is more than 3 black marks. 4, I will again inflict you a punishment. And if you want to inflict a punishment of further reduction in rank, then the value has to be attached to these 3 black marks. You have to,
Which you have already exhausted.
which you have already exhausted. Whether you will carry that value for the 4, that is what troubles. Suppose second situation where 3 black marks and withholding or reduction of the increment, both. Not reduction in rank, withholding and forfeiture of the increment.
Right.
Both are inflicted together. Then you are using this as a reduction in rank as well. You can use it
Milord,
in addition, or it says it can be awarded alone or in addition to any other punishment.
punishment.
Any other punishment is a withholding and forfeiture of the increment is also one of the punishments.
Punishments, absolutely.
So
Milord.
it is in addition to that, it can be
Can be done.
both
Can-
3 black marks
Right.
as well as the forfeiture and withholding of the
Right,
increment.
right.
Both are inflicted.
Right.
Now you utilize these 3 black marks to a reduction in rank, because that is the section. If there is a 3 black marks, then it invite a reduction. So he gets both forfeiture of the increment and he also is inflicted as a reduction in rank. Both
Right.
is, and then the reduction is lifted automatically because the period is
After
given.
that period.
6 months, 12 months period is there. The moment he completes,
He's
he is
restored to
restored to its original position,
original position.
but without any increment. Because the increment is perennial in
Right,
nature.
right.
No difficulty.
Right.
Now,
That is
again,
with, provided it is with cumulative effect. That may be also.
maybe.
Right,
There may be.
right.
Now, what happened? Another black mark came in his original position. Then what will happen?
That will be, this will be given effect to Milord, 836.
Then again you are utilizing same black mark. That's what the problem is. The black marks can't be repeatedly used by you. The value of the black mark cannot be repeatedly used by you to inflict penalty one after another.
So what you are saying is
No, no.
correct. Had it been any other penalty, any other penalty than the reduction in rank, there is no difficulty. Because the value is only attached so far as the reduction in rank is.
No, along with reduction, Milord, I am arguing this side. Along with reduction on rank also, this black mark can be awarded. Your Lordship may kindly see. This, along with black mark also, this reduction in rank can also be awarded.
No difficulty,
You
no
not see-
difficulty, no
So
difficulty.
that is what,
Then,
Milord,
then
this
it will bring inconsistency
right.
that it does not struck in my mind.
Right.
Thanks to you. Because the reduction in rank is also one of the punishments provided in A2H.
Right.
3 black marks are also provided in A2H.
It
Now
will,
you have already punishment. In addition to that, it can be done.
can
3
be
black
done.
marks with a punishment of reduction in rank.
Right.
Now
Double
what you will do with 3 black marks? Double reduction
Will you utilize these 3 black marks
as a double reduction.
and utilize that for the purpose of another A2H?
No, Milord, suppose it is independently done. Suppose no black mark, but reduction in
No
rank.
difficulty.
Milord, there are.
No difficulty.
I'm coming to that.
Yes.
Suppose, Milord, 3 black marks reduction in rank,
Correct.
that is automatic.
True.
Milord, no black mark reduction of
No
rank
difficulty. No
and
problem.
reduction in rank along with black mark. That
True.
is the third situation.
Yes.
Milord, 3 situations.
Yes.
We are concerned with
Our-
third.
Lordship,
First and
I'm
no
coming
ambiguity.
to that. I'm coming to that. Your Lordship may kindly read at this juncture 836. Then what would be the effect of this?
Correct.
836.
Yes.
May I read, Milord?
Please.
9 black marks shall entail reduction in rank or compulsory retirement or removal or dismissal. Whenever any member of the police below the rank of deputy superintendent has been awarded 9 black marks, proceedings shall be drawn up against him with a view to awarding any of the above
Right.
punishments. So 9 similar this is with reference to 835. So that maybe your lordship is correct. It may be read so far the reduction or forfeiture of withholding of increment shall carry this period is associated with this black mark. Suppose, Millard, I was Millard submitting along with reduction in rank, also black mark can be awarded. Millard, am I clear? One situation I have given. Reduction in rank for a period up to 6 months, 1 black mark carries value of 1. Reduction up to 12 months carries certain value 2. Reduction for longer than 12 months, it's 3. So along with reduction of rank, this can also be awarded.
So double reduction.
No, reduction and black mark. You will see.
See, your example is
3
correct.
black marks leads to
Rather,
reduction.
your example is correct. If the black marks are not converted into punishment, if black mark independent,
That's
penalty,
correct.
there is no problem.
That is what I am submitting.
But once you convert it
That
into
I am
both.
submitting. 3 black marks leads to reduction. Suppose reduction is Millard in rank, etc. is awarded. That would be
duty. 824.
no,
black mark-
824 to Millard punishment.
No,
It
no,
should
no.
not have any
No,
ambiguity.
no. See, rightly this F is used. Black mark itself is a penalty. You keep on giving black mark, accumulate it. When it happens 9, you terminate him, whatever you do.
Right.
But intermediately, when you have 3 black marks, you can't convert it, give penalty, and the same 3 black mark again you count for 9. You can't do that.
No, Lordship,
You
it
can't
is
do
not being done like that.
That
I'm
is
sorry,
what you
Millard.
are doing. See,
No.
Then
That is not being done. Your Lordship is interpreting
no.
in a different way.
This-
That is not being done.
Mr. Advocate General, we are
Yes.
not concerned so far as the merit of this case is concerned.
Right.
Because this bench is not really constituted to consider the merit. It will go to the respective bench to
Respective bench.
decide it on
Absolutely,
merit.
Millard.
We are simply assembled here to answer this reference, point of reference, that what should be the correct interpretation of these provisions.
Right.
We will simply answer that what should be the correct interpretation.
Right.
And thereafter, whether he comes or he does not come will be decided by.
No, absolutely. That is not on merit.
So we
Only
are
it's a
thinking in
legal
a very
reference.
broader aspect.
Terms of reference has already been decided by your Lordship in the previous order.
So we
Therefore, I
are
was reading.
considering it in
Yes.
a broader
All-
aspect that
Lordship.
in a hypothetical situation, how
What
we
would
can-
happen?
we can
What would happen?
interpret these provisions, how to
Right.
assimilate it, how to harmonize those provisions by using the interpretative tools. So this is what we are thinking.
No, your
That's why
Lordship is
we
correct.
are thinking in a different
Your
examples.
Lordships, it is absolutely within your Lordship's power to interpret it, to give effect to the provisions, to anything it is left open to your
No,
Lordship. I am not
it's not.
disputing that. I am doing my
You are-
duty.
You are-
I am
you are-
not doing
you are an
my
officer of the court. You
That's
assist,
correct. I am-
to
yes.
take a decision.
That is
If
exactly what.
something is going wrong in our mind, I think that is the, you will assist us
No,
that, no, this is the correct way of
That
thinking.
is absolutely correct. It's my duty to answer your Lordship's query, to clarify, and also my duty also to
This
assist
is what
Millard
the-
fairly.
troubling
I
us.
do not say that because the provision is there, it is sacrosanct. It has to be, Millard, interpreted by your Lordship that finality is always there. I am not very clear on that aspect. I am not disputing that here. So, but the question is, Millard, may I submit once again? Millard, these punishments are spelled out in 824. So many description of punishments are there. Reduction of rank and black mark. They are also 2 major penalties specified under 824. Both the punishments can be inflicted together.
No doubt,
mark or marks.
no doubt.
Milord, over. Then let us, Milord, I am taking your lordship to the second situation, number 2. Black marks can be awarded alone or along with other punishments.
No doubt.
Clear. Milord, if it is awarded alone, resulting in 3 black
Correct.
marks,
Correct.
that would culminate in the award of punishment
No
reduction
doubt.
of rank.
No doubt,
That's is correct.
no doubt.
Only, Milord, that is not with respect to the reduction of rank. Your lordship may keep it aside. Suppose, Milord, a reduction of rank is awarded separately. That is a different punishment altogether.
Correct.
For specified period, maybe
Correct.
for 6 months, maybe
No
for
doubt.
12 months, maybe longer than
Yes.
12 months.
Yes, yes.
So reduction of rank, if it is, Milord, awarded in a punishment, in a proceeding, that has to be, there has to be a departmental proceeding,
Correct.
and the appeal is also there. So there, Milord, the value of black mark would be this.
Now, there are, then, what is?
Milord, that is what
No, no,
835
no.
says,
Sir,
Milord, effect
Mr.
of.
Mr. Advocate General, what you
Yes.
are saying is absolutely correct.
Yes,
This officer
correct.
and the disciplinary authority inflicted a punishment of reduction in rank. He
Right.
can, this is one of the major punishments,
Punishments.
no problem.
Correct.
That is his freedom.
Right.
The disciplinary authority can also impose a punishment of reduction in rank
Right.
and also the 3 black marks.
Black marks.
No doubt.
Right.
Okay. No problem.
Right.
If it is awarded by a disciplinary authority, then the situation is one.
Right.
But if the disciplinary authority has awarded only the 3 black marks, then say that these black marks invite the reduction in rank. It is not that independently the reduction in rank is inflicted upon it.
No.
It is
mark.
because
Two
of the
black
3
marks.
black marks.
That will go,
Which-
Milord. It said it shall not carry any black
Listen
mark.
further, listen further.
That is why.
I am not.
No difficult.
Yes.
Then he may say that these 3 black marks is now converted into a reduction in rank.
Black mark will not carry any value. It is there.
Yes.
824.
That is where.
No, that is the retail,
I'm
Milord.
coming. I'm
Yes,
really
There are the
thankful.
problem.
I'm
Right.
really thankful to you
Right.
that you have.
Right.
Please keep this in your mind.
Right. It is
Keep
there,
this
Milord.
in
It
your
is
mind.
there in the
No,
statute
that-
itself.
after the problem.
Then
Yes.
thereafter the problem.
Yes.
Then you are correct.
Right.
The moment it is converted into a reduction in rank,
Right.
then this black marks will not carry any value.
Value means, Milord, that would be
1, 2, 3.
1 to 3.
Can you utilize
One-
the same black
now-
mark once again?
Because
This
it
is a
will
stigma,
not-
Milord, that has to remain.
No.
Huh?
No, Milord, if it doesn't
No,
go,
no,
then-
no, just 1 minute. That
Milord,
is what,
can I permit a person who repeatedly commits delinquency and still be a member of the force?
no, I am just, that is where the problem starts. Because you are absolutely correct when he says that this black mark, 3 black marks will not carry any value. Because it is, this value is utilized for conversion
The
of
penalty.
the same into a reduction and there is another penalty. It
Right.
is utilized.
Right.
We have no the quarrel up to this proposition, no problem. Now, the problem starts, the subsequent provision says that these black marks would remain, it will not lapse. It will remain. 837 or 836
837.
35.
or 836, what?
Permanent, no?
It will remain permanent.
37. Period is over. The 836.
Subsequent rules. Subsequent enforcements.
That's what I'm saying. 837, please read.
mean
That
permanent.
is what, Milord, has been interpreted. They
No,
say
no,
that
is
it
why, that is what is.
black marks.
837 talks about that this black mark
Yes.
will continue.
Shall remain permanently. That would be entered.
That means this
Milord,
black
it
mark
can be
shall.
obliterated.
Uh-huh.
If
I'm
somebody
coming, I'm
has
coming.
been.
I'm conscious because language is very clear.
Right.
It says that this black mark will remain
Permanently on record.
So it
Yes.
will be there on record.
Record.
And then thereafter, the conjunctive word is used and be taken into consideration
Yes.
in deciding the nature and extent of subsequent punishment.
That is the past conduct. Because of 836 million.
That will be given. Now, suppose in a subsequent punishment, the authority decided to inflict one more black mark,
Right.
which is also major penalty.
It can be awarded anytime, Milan.
One
Black
more.
mark
Now-
can
now-
be awarded anytime.
Correct.
Let me come-
So this one more black mark is awarded subsequently. Suppose if these three black marks would remain permanently on record, then one black mark further addition will make it 4.
Yes,
No difficulty.
no difficulty.
If it remains, becomes 4, and then say be taken into deciding the nature and extent.
Right.
So then the authority may decide the nature and extent of subsequent punishment, decided reduction in rank again,
Once again.
once again, for one black mark subsequently added. Again, then for that purpose, he has to calculate the value of the earlier 3 black marks. And
But
then
yes.
section, this rule 834 says that such reduction or forfeiture or withholding of increment shall not carry any black mark value. Then you are again giving a black mark value to those.
Same black mark is being utilized again and again for the inflicting of the penalty. Is
Which
it
is
permitted?
here troubles, because how can you utilize that? You can understand that this black mark will not carry any value, but if it reaches to 9, everything is done. Then you can inflict a punishment of compulsory retirement. You go out. Now you have got this 9. It is permanently there. No difficulty. Go out. You can throw him out because you have not amended your. We have also no problem into it. But we have a problem when you decided to inflict the punishment of reduction.
Imagine another situation. Nine black marks.
This is what
First 3 black mark converted
No,
to
no, that
reduction.
I have to revert back what they are following. No, your lordship.
No,
Milord,
not
they
following. What
operate
is
in
the
different
law?
fields. There is no overlapping. Milord, your lordship may kindly understand. 834 clause B, Milord, and 835, they operate in different fields altogether. Yes, Milord, your lordship.
One complements
is same.
another.
No, no, one it says
complements another.
Can I give one more
three
example?
black marks.
Mr. Acharya, can I give one example? First, there are 3 black marks. You inflicted the penalty by converting it to reduction.
Right.
Thereafter, another 3. Again, you have gave the penalty.
Reduction
1
of
minute. Thereafter, another 3. Again, you have done. Thereafter, at the end, you see that there are 9 black marks.
Right.
Therefore, remove him from the service. Then, for the
Right.
same 9 black marks, he
Right.
got 4 penalties.
for
3 penalties.
maybe Milord during the service
No,
career,
that
if
can't
he
be.
goes on, no Milord, because a punishment has been inflicted once, so he cannot be proceeded again.
No, that's not the issue. You can't utilize this black mark for the purpose.
No, we are not
Correct.
utilizing for that purpose. Your Lordship, there is the problem. Milord, black mark, 3 black mark leading to reduction in rank and reduction in rank with forfeiture of increment are 2 different things under 824.
Perhaps we are not clear or we are not able to, make ourselves clear. There is some dichotomy somewhere.
Milord, should I address at a length so that it would be in a piecemeal manner, Milord, the argument I can
Yes.
convey. Milord, if I read each provision after another, then it would give a sense. If I argue it in piecemeal manner, it can't be understood in its proper context.
Then get that book.
Either your lordship may allow me some time to argue and put my point, or your lordship may decide the issue. I am not able to submit what I intend to convey.
Who can stop you arguing?
Let your lordship finish this, then I will start.
Mr. Advocate General, I think you 2, 3, 4 things as we have already expressed in our mind, and we need the assistance from the bar, and you are also appearing. We have to be very clear. We are not entering into the merit. We do not want any argument on merit. We are simply on a point of reference and a question of law. That what should be and how to harmonize these rules so that they work together. So this is what we expected an argument.
So I will submit in that
We
line.
invite any member of the bar also if they can be of any assistance to us, because it is purely a question of law.
Yes.
It is not relatable to any facts. So, and Mr. Advocate General, also please ensure that what is the genesis of this,
The first question.
the first question.
My lord, I
Because
would.
we
I have
give some
already
kind of a,
understood,
yes,
my lord,
my
Justice
brother,
Raman has
my
pointed
brother
out.
noticed.
My lord, it's
I
very
was
beautiful.
misled by the head note and the Odisha police rules. So I proceeded, it is the rules. So there was no difficulty. It's the rules.
But
No,
Definitely.
that
and
is a nice
statutory,
question. I
right?
will answer that.
But that's something struck in our mind, then we have to clarify.
So
That
please.
we can't assume that this rule is bad and it doesn't have any
No, no,
genesis.
first
Is that rule, my lord? I have to
No,
gather.
then Mr. Advocate General, if it appears that it is not a legal document in that sense where enforceability can be done, then we can definitely shirk our responsibility of
Right.
going so
Answering the
deep and answering those references. We will say that the reference was unwarranted. It was
Right.
not required.
Right.
So we can drop the proceeding then and there. We will not go more deep into the matter. So please consult.
Yes.
Consult.
And this also I was reconciling with OCS CCA rules. Because bereft of OCS CCA rules, you are not deciding this.
So that question. No, that is under 309, different.
309, but for imposing and inquiry.
No, that is not to be.
No, it is
This
an
is under
exhaustive-
PS.
it is
So
complete
my lord,
exhaustive.
on that point, it has been under
It's a
309
complete
doesn't
exhaustive.
apply.
If it has a legal character,
Right.
then it is exhaustive one. There is
Right,
no doubt
exhaustive.
about it. Every
Section
mechanism,
2,
methodology is given.
Section 2, because, my lord, I'm sorry, 309, that is applicable for the civil service.
Yes.
So CCA rule is a creature of Article 309. This is a creature of this Police Act. It's a special
It's an
section.
exhaustive one, the procedure and everything.
No doubt. Let us see. Yes.
Any,
When
let after vacation, let it come. There is no urgency.
we will lose all. We have
No,
applied
actually,
so
my lord,
deep into
this
the
particular two
matter.
I'm stuck up with many matters. That is the problem. Delhi, Cuttack, it's very difficult. And next week, my lord, I have a plenty of
Because
matters. All partners, they are not.
1.5 hours hearing will go waste. We may forget it. And you will overpower us.
My lord, Justice Mishra, my lord, he goes, he must have booked some foreign tickets by now. So let him know this.
Why you spare my other brother?
No, my lord, Justice.
So-
Raman. Lord, I am sorry. In fact, my lord, Justice Raman, I will clarify your lordship's query. It's not because my duty is also to see that
Yeah,
my
this-
rules are.
That's a request from the bench, this side of the vacation, because we wanted, this has been
Any-
pending
then
since
your
long.
lordships.
And I was
My lord,
told,
any day, then after, say, after 9, my lord, on 13th, your lordship may call, 13th or 13th, my lord,
Yeah,
13th of May, at 2 p.m., my lord.
morning,
because the-
everybody is
morning.
absolutely
Ah,
fresh, no problem.
That
The
is
mind
correct.
is also fresh.
That as your lordship pleases. 10:30, 10.
It's a regular bench because there's a special bench. So after that, go and do the bench. So in the morning better.
Lord, next date I will come back with this rule, the genesis
Please-
and the
Please
background.
consider, you also
And
consider,
please carry the gadgets because there are a lot of types.
I'll get the original.
Lot of types.
please do that. Yes. The argument argument by the learned advocate general comments. And in course of the question fell for consideration on the genesis of the what we call it. The genesis of the provisions contained in chapter 25
Of the police manual.
there is a manual or what?
Police manual.
Of the
Left hand side.
of the police of the Odisha police manual. To which
ये बिक्री होगी बोलो हम कब
No. Whether there is any authentic book from the department side, department's compilation must be there.
Yeah,
Department's compilation
no let's
under the authority of
They-
home department.
let's see
lot of typos.
there are a lot. What you say was correct.
Sir, I mean, no, Bhartan, it's a cooperative
no
society.
your RCB is correct
You-
there
you
was a
were
wrong
arguing-
decision
You
also
were arguing, incidentally, I was hearing that
No, that's-
when
I pointed out
you
that it
pointed
is
out
not
that not is omitted while printing the book.
Yeah, you'll also be
Entire
correct.
scenario
Yeah.
changes, sir.
there was a
No,
wrong
that is
decision by Justice PC Naik, so I submitted its due to be because not I was
That's in court
submitting
number
it.
6 old.
Yes very old
We wish that the book which you are going to get,
no I will carry a correct book now
correct book,
I will
there,
not rely upon
black
this
mark would not be there. So we need not do anything.
I'll come
Who is the learned advocate general? 610. On the request, this the matter on 13th.
It is.
13th May to be taken up at the first sitting of the court. Yes.
Pardon to mention, my lordship. My lordship, it's a matter relating to no confidence motion against the Sarpanch. My lordship, it is going to be held on 28th of this month, but they gave us the notice on 24th of this month. My lordship, today is the only day that the matter can be heard. My lordship, we tried to list this matter before the
Why you
bench, but
did not
yes, my
close the
lordship.
bench till that matter?
My lordship, we tried it, but unfortunately, it is not on the list. My lordship may take up this matter as a special
How can
notice.
we? How
My
can
lordship,
we?
may direct honorable bench.
It is a roster of another bench, then
Item also, my lordship.
can we?
My lordship, because 20 is the last day, my
Go and
lordship.
convince the bench, no difficulty,
My lordship, we tried it, but subsequently,
whatever.
my lordship, matter is very urgent.
The committee of the judicial discipline has to be followed.
My lordship, only my lordship is.
We
if
can't,
one-
that the other honorable bench did not consider it so urgent. We can't. It should not be proper.
My lordship can.
No.
Your appealment. Your lordship, both of the writ appeal may be taken one, I brought notice before.
Give.
My lordship, may I request one more thing?
Madam.
My lordship,
that's a
my
judicial
lordship,
discipline.
leave-
Madam, that is a judicial discipline. Kindly please appreciate this.
My lordship, with the leave of the court, can I
No,
place
then
before
we
the
are
honorable
really
bench, my lordship?
sitting as a court of appeal over the coordinate bench. That's not proper.
Bless my lord.
My lord, one matter is WPC 2010 matter.
Sir, pass on the memo.
The Honorable Supreme Court remanded
Please,
matter.
pass on the memo, sir.
Supplementary list, item number 1.
Your Lordship, pardon, Your Lordship, I would like to mention a matter. Your Lordship, I am on VC. May I be allowed to mention a matter, Your Lordship? It's a WPC 4334 of 2022 filed by my petitioner. I am for the petitioner Bachpan Andolan Bachao.
Sir, please, file, pass on the memo, we'll consider. it.
I'll do, Your Lordship, in the course of the.
Yes.
Obliged,
Item
Your
one.
Lordship. Obliged, Your Lordship.
Item
Please,
number
what has
1.
happened?
This matter was before your lordship's.
Yes,
My lord,
invited his
I have
attention
talked,
to-
your lordship, may kindly, I am passing out my instructions. My lord, they said that our hands tied. We cannot go, my lord, with all due humiliation, my lord. This is the instruction I have received, my lord. I have stated that this SLC is dealing with PDS and some leniency should be extended to him, my lord.
I think 16 circular, section 16. It is only, isn't it?
Yes, my lord.
So on that basis, CBSE has brought forward some circular saying that such type of mismatch should be leniently considered.
My lord,
On that basis only, in order to get some revenue under section 50, subsection 3, you should not insist upon merely because some other, it is dependent on some other supplier and his actions. And furthermore, it is an initial period.
Yes, my lord.
So initial period, you had no returns properly placed on the website also. So you allowed them to file returns much later also, in 2019. In 2019, clubbing up all transactions relative to 17, 18, 18, 19.
But
They have filed returns and they have availed input tax credit also.
But my lord, difficulty is when once they have issued show cause notice and a proceeding under 73 has already been
Understood.
initiated, whether they can go back, it is difficult.
No,
That
we
is
are
the
not
problem.
saying that. So we are saying if he will be allowed to produce
My lord.
account along with the returns. Yes.
Your lordship.
My brother will take care of.
My lord.
Yeah, take care of instruction.
Obliged, my lord.
Reserve.
Much.
Reserve. What is it?
One chance.
My lord. And only one prayer, my lord, it may not be taken as a precedent.
That will see,
Obliged.
that will see.
Affording
In
a chance of personal
hard
hearing.
case and hard circumstances, let us see.
Greatly obliged.
Item number 2.
May I please, Your Worship? And through that action, my lord, so far as 14, my lord. At page 57, my lord. Got it, my lord?
This is from an RTI information you are coming at.
My lord,
This is from RTI. You were the only sole applicant.
yes, I was the, with your lordship's permission, I want to draw your lordship's
It was-
attention
it
by
was
page
me.
65, my lord, of that order, my lord, judgment.
It was me, the sole applicant,
Who are sole applicant.
Yes.
They.
in terms of notice.
You pursuant to the advertisement, you applied.
Much obliged.
Fundament with the process of selection.
Yes, my lord.
And then it is there, no difficult.
Yes, my lord, to that I want to draw your lordship's attention. For the first time, I want to draw. Yes,
You find a counter there.
because we are,
Did you file a counter?
because
He
in
didn't
that.
appear, Your Lordship.
Just a
In spite of
minute.
knowledge.
Know that he appeared.
Sorry, madam.
I'm just simply asking whether he filed any counter.
No, because what has happened, no, because this is the difficulty for that reason, I am not able to file it because I have engaged advocate, he did not appear in that case, which was not with my knowledge, as a result of which were not filed counter.
It's better to go with the before the same bench.
Much obliged.
Now, they're convincing to the judge. Matter ends. Why the appellate court will go into.
Madam, I have taken the ground 14.A, my lord, at page 8, my lord. And also, with your lordship's permission, may I place that, what your lordship is posing a question to that text, I have given reply in 14.
There are two.
Yes, ma'am.
If your demand is that you engage the lawyer
Yes,
to take care of everything. The
My lord.
lawyer did not appear.
Yes.
There was some kind of a lapses or the negligence on his part.
my,
Then you may definitely go before the same judge. Make him aware, if he records.
Yes,
the
ma'am.
order,
Yes,
records the
ma'am.
order. If he finds no, there is no merit, then.
yes, madam, much obliged to that extent, my lord.
No, that is good.
With that observation, disposal.
Uh, you're not touching the- You are the respondent number 5 or 4 there,
And four, I have 4, my lord.
you are 4, 5 has not come before us.
Has not come.
Yes, not come.
The respondent number 4 of the petition has filed with some key. Sealing the order dated 17/12/2024.
Sorry, my lord. Pardon, I'm 5, my lord. Sorry to that extent. I am a big apology, my lord, to that
Fine.
extent.
Sealing the order dated 17/12/2024 passed by the single bench in WPC within bracket OA number 290 of 2019. On the ground that though he was served with a notice of the said writ petition and engaged the lawyer to represent him, but subsequently the said lawyer did not appear. And the order and the improved order is passed in his absence.
Not.
By the impugned order, the single bench proceeded on the basis of the pleadings available before it, that the writ petitioner respondent was the sole candidate who offered his candidature on the basis of such publications and or advertisement made by the authority for recruitment to the post of, what is the post? Post to the
Research
post of a
assistant, research assistant, my lord.
research assistant within
Yes,
state
madam.
non-gazetted
Yes, my lord.
post. The counsel for the appellant vociferously submits that he also offered his candidature pursuant to the said publication. And he has a sufficient evidence in support thereof. But because of the lackadaisical attitude of the lawyer engaged by him, the same could not be brought to the notice of the single bench.
My-
We noticed from the tenet of the order that the single bench proceeded to decide the matter in presence of the petitioner as well as the state respondents. Obviously, in absence of the present appellant, who was not represented on the said date, the appellate court should not venture to go in such aspect as as the point raised in the instant appeal can be agitated before the single bench. And there is no fetter on the part of the single bench to decide the same on merit. On merit decide the same on the basis of such contention on merit. We thus grant liberty to the appellant to make an application before the single bench, raising all the issues as raised in the instant writ petition. And in the event such approach is made, the single bench will decide the same on the basis of the merit of the source of the said averments. Stop. The appeal and with these observations, the appeal and applications are disposed of.
Deep obliged.
Item number 3.
Your Lordship, item number 3 on behalf of Mr. Durga Prasad Nandas. Your Lordship, I Mr. Durga Prasad Nanda, Senior Counsel for the Appellant, Your Lordship. May I kindly take a passover?
Yes, madam, sorry.
Your Lordship, item number 3.
Yes.
I'm for the appellant. I'm appearing on behalf of Mr. Durga Prasad Nanda, Senior Counsel for the appellant. May I kindly take a passover, Your Lordship? He's on his legs in a different.
You are carrying a voluminous papers, so are you not there in the matter?
I am.
Argue. There's a good opportunity for a junior to argue the matter. We assure you that if in the event we want to pass an order against your client, we'll postpone it till your senior comes.
Your Lordship, this is a matter where the delay, the implementation, the punishment imposed on the appellant was implemented 9 years later. Then it was the punishment was imposed in 2011, Your Lordship, and thereafter.
It is sought to be implemented when?
After 9 years, and that too, it was according to the authorities, it was the responsibility of the appellant herself to implement the punishment.
Yes.
It was not. So I mean. So after the punishment was issued, no implementation was taken, no action was taken by the authority to implement. In fact, she was given a promotion to not a promotion per se, but okay, she was the appellant was transferred to after the punishment. The appellant was transferred to SCB Medical College and subsequently. He was also in the GA notification in the GA department. The notification of GA department has it also outlines the procedure for the enforcement of the penalty. So which. Delay. And the punishment was imposed in 2011 and they are imposed in 2019. And that is.
Single bench has held that you were in the helm of affairs because it was everything is dealt with by you and you secretly or hide it for some purposes and did not communicate to the higher officials for taking as steps. So on that score, this single bench held that since you were responsible for communication and having not done because it will affect your service care.
It is affecting mine. I am not being promoted.
You consciously suppress that particular order and did not let it go to your higher officials. And there the court says that the one who is a wrongdoer, the equity does not lie in his favor.
Your Lordship, may it be taken as the last item in the board. My senior will come.
Call your senior. They're called.
It's the last item in this list. Of next month, Your Lordship. On 31st May. Last item. in the-
Or your lordship may keep it to Monday so that.
Monday is a holiday, Your Lordship, and Tuesday is fine.
Come as the last one. Yes, if she can secure the senior's presence, no difficult.
Item number 4.
Oblige, Your Lordship.
Please, your lordship. And here, the issue revolve around only 2 points. Section 24A and C of
Where is the
in
impugned order?
19, page 19,
Order
page 19.
16/12/2024.
Yes, your lordship.
Just give us 1 second. So your only grievance was that there was no service of notice.
My lord.
But the court held that yes, there was a service of
My lord,
notice.
sir, it is in.
Now it has to be, was it sent by a certificate of posting or?
Yes. That,
Under the law,
Yes.
section 24
requirement.
postulates service by a certificate of posting.
That is a requirement.
And also contains express provision that it will not be invalidated simply on non-service.
Yes, ma'am. Not only that we submitted before the honorable single judge that we have given the notice, but also that was accepted by the honorable single judge. That it has been solved. Para 4.
Annexed,
Where is that rule? Show us that it says that mere non-service will not invalidate. I think there is express provision there.
Yes, yes. OGP, OGP rules,
Orissa Gram
Gram Panchayat Act 2014. 24.
24 is the section.
The rules to
Rules and that.
Rules one. It should be seen to all the members.
May. Gram Panchayat Act section 24.
E, is it? If you look at E. In the fourth section. Counter this one type, counter this one type, that was very particularly. No, it is that, what is the section once, the same time. Sent by certificate of posting, then SENAF.
Yes.
And it will not invalidate, merely that you did not receive that.
No, a question also whether there is 15 days notice or not. That is also the session.
No, that is, where you have made out a case that it was a short of the statutory period.
My lord,
Where you have made out a case.
my lord, it is amply clear from
No,
their
no.
document itself.
No. sir,
Annexed
it was-
G/3.
Mr.
They have said that it is solved on
Mr. Das,
16.
Mr. Das,
My lord. Oh.
in the counter affidavit
Yes.
filed by OP number 3, before the audit code,
Honorable Singh.
paragraph 5,
My lord,
he has enclosed many annexures showing that for better appreciation, copies of requisition along with a resolution letter dated number so and so, so and so, so and so, so and so dated, and copy of acknowledgement of Sarpanch so and so regarding receipt of notice on so and so date are annexed here with us, annexer A by 3, B by 3, C by 3.
That is what I am
That
referring.
means
That is I am referring. Those documents I am
Please
referring.
refer to us.
Page 31 from the counter affidavit.
Yes, where is the counter affidavit?
computer page 53.
No, where are those annexures? Please find out. those
Annexure G by
annexures.
3. In
Annexure B.
G, pardon my lord. G.
G.
Hmm.
G for Gram Panchayat.
Yes, your lord.
G. Oh. Or G by 3.
Yes, your lord.
Oh.
Oh my God.
Where is that?
For instant reference, if your lordship.
What is
What is the page number there?
31.
31.
No, we can go to 31.
Yes, sir.
No difficulty. We got it.
My lord, my lord.
No, we are talking about the, this is what is a letter dated 20th of November 2024.
My lord.
No difficulty?
It is the letter of the BDO to the sub-collector
Oh,
indicating that on 16/11/2024, the notice was served upon the petitioner, my lord. Now, 15 days is the requisite of
where you have made out a case of such nature
my lord. From the
after the counter, you file a rejoinder,
my lord, rejoinder has not been filed.
then
In fact,
if they have disclosed something in a counter affidavit, then you should you should alter your position in the rejoinder that the thing which was not known at the time of.
my lord, my lord.
The Honorable Single Judge is very clearly stated that this is the only point you have raised, that you have not received the notice.
My lord.
That is the only point.
My lord.
So he proceeded on that.
My lord,
Where is the information?
If you abandoned a particular point, did you appear before the single bench? Somebody else. Very difficult, sir.
But one thing, your lordship, my lord, just upon filing of the counter affidavit.
Before the admit court, without any. Was from this document G3. When, what do you say, the date of?
My lord, may I read the second paragraph of that letter? Further, I am to intimate as per version of PO, and my lord, PO stands for Panchayat Extension Officer, that PO has visited to the house of Srimati Bharati Suna Sarpanch on 12th November, 13th November, 14th November to serve the notice upon her. But Srimati Bharati Suna Sarpanch was not available in office nor in her house. On 15/11/2024 was a government holiday. The PO has tried to serve the notice and finally found near GP office.
No, that may be a different, that's another mode. Have they produced the document that it was sent with the certificate of postage?
They have my lord, page 27 onwards. They have sent through, they stated to have been sent through
Certificate of postage?
no, registered post.
No, no, it says that under the certificate of posting.
They have followed the registered post method. What it born out of counter, my lord. Page 27 onwards. But it doesn't tell the date on which it has been sent.
So supposed to.
This document doesn't indicate when the registered post was made. Page 27, my lord.
Yes. There must be a date.
Nothing, my lord.
So you can't make out a case from there.
At least this, they have admitted they have sought upon me on
No,
16th.
sir, once they dispatch, which is the requirement of D, then non-service will not invalidate.
My lord,
And you really did not take that plea in the trial court.
and
You could have- you
if your
could have
lordship, if your lordship
sought
permit
for
me,
an amendment of your writ petition, or at least in rejoinder, you could have raised this issue.
my lord,
You did not.
so far as the requisite of this notice period, my lord, if your lordship permit me, I can. I'm relying on a decision, my lord.
That it has to be done.
My
It
lord.
says that the 15 clear days before the dates
My
are
lord.
fixed. I am conscious.
My lord.
That was not the point addressed
But
to the Honorable Single
That is what I have seen. That's why I am saying. So it's really a
24C was urged. 24C, that the requisite of 15 days, and that is how the Honorable Single Judge has said, the compliance has been made of A and C. But as it borne out of record, C has not been complied. With all respect,
this must be also published or copy was pasted
No,
in
no,
the-
no,
in
my
the-
lord,
in
no.
the, notice board.
No, my
Notice
lord,
board.
those statements has
Notice
not
board.
been made before the
Notice
Honorable
board.
Single Judge, my lord. Excepting this letter of BDO of 20th November. No other document regarding service and 15 days clear day notice period, my lord.
Huh? No, sir. Nothing could be borne from the record, sir. You are making out an absolutely new case, being a new counsel engaged at the appellate stage.
No, my lord, that ground I have taken in the writ petition. That ground I have taken in the writ
But
petition.
there was no
Rejoinder would have.
Should have.
Would have.
Should have.
I bow down, my lord.
Should
But
have.
question is, my lord, when it is borne out of the record or the situation position is telltale from the record, I think the second thought is not possible.
Just it is a 10-12. And when the meeting was held?
A meeting, my lord, subsequent to this date, another date was fixed because by then 28/11 was the date fixed. Thereafter, but this order was passed on 16/12/2024. In the meantime, a fresh meeting has held, and
When?
that date I don't have with me instantly, my lord. But I have lost the confidence. And one thing, if your lordship can allow me at least to audit this through a review, then that may, because that is my right.
That is your statutory right.
No review, my lord. Your
But I
lordship,
do not know because if we go into the merit and then decide the appeal, whether the review would be available, I
no,
have a
once
doubt.
your lordship, my lord,
I have a doubt.
once your lordship will touch the on merit,
So
my lord.
it is up to you what to do. If we touch on merit, we have
No,
to review.
no. Thereafter, I cannot seek even, my lord. So what I
So
pray,
it is what you
I pray,
force,
my lord, since your
it is
lordship,
up to you. What you pray.
your lordship may permit me to go for review at least, whatever.
How can we permit you? There is a statutory right.
Yes. Withdraw kariye.
It's up to you to take a decision.
With this submission, your lordship may permit me to withdraw.
No.
No, not exactly review, to exercise my alternate.
That is
That-
there.
the-
The the counsel for the appellant submits that the appellant has decided to exhaust the remedy otherwise available in law, then pursuing the instant appeal and prays for withdrawal thereof. The appeal is dismissed as withdrawn. Call the next.
Can it be item 5 disposed of as withdrawn?
How can it
Because-
be disposed of? Then it will create a problem to you.
This is a PIL matter, regarding the non-implementation of the power project within the eco-sensitive zone of a Kapil's Wildlife Sanctuary matter. Initial, they have violated the MOU and
Item number?
5. But the state authority, they have failed in setting up the power project in the notified villages of Khondwali, Kandrai, Dalua and Rahangol in the district of Cuttack matter. And the mandate was got from the
Sir, you
honorable-
simply wanted that the purpose for an acquisition, public purpose is lost.
Yes, my
So
lord.
every property, whatever is under the acquisition should be reverted back. This
Yes,
is
my
your
lord.
prayer.
Yes, ma'am.
Tell me, under the Land Acquisition Act, Act 1, after the acquisition proceeding is over,
Yes, my lord.
can it be reverted back solely on the ground that the purpose for which it was acquired is lost?
Yes, my lord.
Can you?
Annex 4 is the mandate of this honorable court in a PIL petition, my lord.
I do not know because the section is the moment the acquisition notice under section
But the
4,
very purpose of,
declaration under section 6,
but the very public,
award is
my lord,
made by the collector, deposit is made, and then the property vest into the state absolutely, which cannot be divested.
what is done, my lord, Annex 5, my lord, may can see.
You wanted that everything should be reverted back. It
My lord, the
once it is
preconditions,
vested, cannot be divested.
my lord, the preconditions given in the MOU and the land acquisition,
But that was after acquisition of the land by the state.
but the preconditions are there, my
There is
lord.
no precondition for
Yes,
acquisition.
my lord, kindly turn to Annex 2, the land acquisition approval, government approval that has paid 28, my lord.
Property vest.
The preconditions of the state government are often the EDCO.
Sir,
I would- I would-
very simple thing.
Yes,
When
ma'am.
a state initiate of proceeding means when you publish the notification under section 4 of the Act 1, that is the Land Acquisition Act. Then the public purpose is there. It may indicate the public purpose.
But the company,
That for purpose of, let us see, for the purpose of establishing a factory
but the,
or a mines.
but they
Let
have
us see.
not, yes, my lord, that is my
I'm
case.
giving you for a mines. And then the proceeding was completed. Land was acquired. But later on, it was found that no factory can be set up. Does
Yes,
it
ma'am.
mean that the land which has vested to the state will be reverted back to the persons to whom the entire compensation is paid?
Recently, the Honorable Supreme Court has given a
I
mandate.
know
in the-
3 against you. Show me that which is not known to me. Because I know this 2-3 judgment of the Supreme Court which says once it has vested, even if the purpose which was there for which the acquisition was made is lost, that does not mean that the land has to be reverted back to all the owners.
But they are, what they have done, the company proponent, my lord, they have sold out the acquired property to a person who is
That
not.
is their property because it has vested. Now you lost your title the moment the acquisition proceeding
Well,
is over.
Can I draw your attention, my lord?
Yes.
My lord's attention to page Annex 5. That how the acquired land is being given to alienated to a private person who is not a part of the land acquisition proceeding or the
No, the public purpose is the paramount consideration for acquisition process.
That has been
public
vitiated.
purpose.
That has been vitiated in this case, my lord.
That is what I am asking, sir. The question is, suppose the purpose for which the land was acquired, that purpose is lost, is not complied with. Let us go to that extent. Does it mean that the entire acquisition proceeding lapses or becomes non-est or becomes invalid? I am asking this question to you.
Let it be adjourned to next week. I will come prepare with this.
To you, sir.
Yes.
Find out the law, satisfy us.
There is a provision
No
under section 48.
Please look at that.
Yes, madam.
Yes.
Under
please.
section 48,
Because
there
the
is a provision
difficulty
to.
is
Yes,
my
madam.
own judgment in another high court.
Difficulty I have not come with the book, so that. That
I
is
have
section
held
48.
otherwise. I have held otherwise.
All right.
So please come. That's why I'm putting so much of questions.
Yes.
I am still open.
Yes,
If you
ma'am.
can satisfy me, I was wrong there. I will correct myself here. Don't worry.
No, my lord. I will. There is a provision, my lord, to restore the
Satisfy
land
me?
with the
When you want,
next week, my lord. One week after.
anything you say,
Yes,
any
ma'am.
day, subject to your convenience.
On 29th. 29th. In the week commencing 29th.
You,
Okay.
up to you.
1 week after, my lord. Sir.
Tell us the date.
Yes, my lord.
9th May.
9th May.
Yes. On the prayer of the night. Yes, call.
Item 6.
May I please, your lordship? My lord, similar matters have already been admitted by this honorable court under 16(2)(c). My lord, the challenge is 16(2)(c). I'm just told by the council, the side council, 81, writ petition number 81 of 2025.
Where is that?
The question herein is,
GST.
my lord, the question herein is, my lord, I am a purchaser, my lord, I have got valid invoices.
Your corresponding one, he has not submitted the return or did not deposit the.
Yes,
So
my lord.
whether you are entitled to an input tax credit.
Yes, my lord.
That's the point.
Yes, my lord.
Where is that? The matter is pending.
Lady 81 was me referring there, your lordship, see, that is not the, virus has not even challenged. He has challenged that order in that 81. What?
No, even the first, I have challenged the virus. Virus also I have
No,
challenged.
here, what, but the
No,
cover case
here
is-
also he has not challenged.
My lord, I have challenged, my lord.
He
My
has
lord,
not
even-
challenged the virus.
This is
He
challenged, my lord.
simply challenged that the order of the authority contravenes Article 14, 19(1)(g). So
No.
order is,
Already on the challenge. My lord,
but
even in
not
first,
the provision of the act.
my in the placitum of my, in the first nomenclature, kindly see. I have sent an application challenging the constitutional validity of the, of section.
Yes,
He has got the prayer. Prayer number one.
prayer one is there. He challenged that.
Challenge the virus.
yes. So
So
that
many
is the
cases
notice has to go to
Yes, yes.
advocate, I think, to Deputy Solicitor General or
Yes.
what?
Lord,
It should go actually to a Attorney General.
three formula DSJ has to accept notice, and 4 and 5 I am appearing. 4 I am appearing.
So
1,
so
2,
notice to the
the Union of India, DSJ.
DSG.
Yes.
Since the virus of the provisions contained under section 16 within bracket 2 within bracket C of the Central Goods and Services Act 2017 is assigned in the instant writ petition, the notice is required to be served upon the Deputy Solicitor General.
For opposite part number 3.
Full stop. Issue notice, whatever. Deposit.
My lord, in the meantime, that.
And one.
Of restriction on deputy officer.
1, 2 and 4 I am appearing.
General
5 is just private party.
for High Court of Orissa. And serve two adequate numbers of copies of restriction on Mr. Tusharkanta Satpathy, serious criminal concern, CGST, for opposite part number 1 and 2.
1, 2 and 4.
1, 2 and 4.
4.
So notice to 5. Registered post to credit within 3 days. And this is matter on so date along with other matters are.
Is it on the next week?
No, Your Lordship, I have to take, Lord, it is from the board, I have to take instruction, so.
No, many virus matters on 16/2. What is that number?
Lord, there is a number, I'm just,
Huh.
there is a number, I will pass you down.
The entry orders were passed in that, in virus matter.
No, Lord, subject to result, no stays, but subject to result.
Pass on that.
And I'm just giving.
Coercive action has been stayed.
No.
So
It
I
is said
lost
the
touch.
impugn order.
I lost touch, so I do not.
Yes, but
remember.
just a minute. But I'm just giving. Yes.
For quite long time, I was not
No,
there.
say-
Here or an order where it is
Yes.
clearly written.
Yes, please pass on that.
I'll do that.
Yes, call the next.
That is WPC number
81 of-
16242 of 21. 1262421 Sri Gopal Alice Private Limited versus Union of India. There, Your Lordship felt that in Soparaja, all action taken in meantime would be subject to outcome of the present litigation.
Mr. Satpathy, pass on to my postmasters.
Yes, next. Madam.
Item 7.
May I please, your lordship? Lordship, impugned is the rejection order dated 17th February 2025. Lords, passed by the Commissioner of Income Tax Exemption, your lordships, under annexure what?
192B.
Yes, yes, my lord.
192B.
Yes, my lords.
Yesterday, what happened in that case? What orders were passed? Similar to that.
This is a
Lordships on, yesterday, your lordship, my lords has directed your lordship that the circular 16 by 2024, your lordship, I have enclosed my lord circular. And your lordship, that was relating to assessment of 21-22, my lords, I am with assessment of 2021. And because of your lordship, COVID-19 pandemic, my lords, it's also covered by the civil suo motu, my lords, Honorable Supreme Court, limitation, extension of.
Your Lordship, in this case, yesterday, it was the day. That matter was to decided on the circular. Circular 5/12/2020, of circular 16 of 2024. Yesterday, it was not given, that circular was not. In this case, the circular has been attached. But in our case, the commissioner has rejected this.
No,
On
he's
10
taking advantage of that particular extension of time. He's taking advantage of that suspension of the operation of the limitations
Exactly.
during those COVID period. So in that event, he is asking for, and his claim has been denied because he has approached belatedly. That's the only question.
Yes.
So in that event, what to do? And he's taking advantage of that suo motu writ petition initiated by the apex court, suspending the operation of the limitations,
Lordship.
both under the general act as well as under the special act.
Your Lordship.
And this is a special act. Okay. Yes.
Item number 8.
May I pray, Your Lordship, that the matter be taken up as the first matter after lunch?
Why?
My learned
You
senior
are-
just went out. My learned senior was waiting. He went out for lunch. If Your Lordship permits.
Yes, what do you say?
Your lordship, with great respect, with your lordship's permission, I have the preliminary objection. Let the preliminary objection will be decided so as the maintainability of the writ.
If my learned senior will argue, I'm ready in the matter.
Writ petition maintainability.
Your lordship, because this is the 2017 assessment order
I'll place
has been
merits, Your
challenged, your
Lordship.
lordship, in 2025.
Your Lordship, may
After
kindly,
8 years.
Your lordship.
I'll place
Any
merits.
explanation
Yes,
is offered?
Wrong forum. wrong forum, your lordship, which
Section
is not
14
applicable.
Section 14,
Yes,
That
your
is not,
lordship. Absolutely, your lordship.
that is not applicable, your lordship. I can
Section
convince you.
14,
Yes, your lordship.
principal.
Yes, your lordship.
No, that he has filed one application,
That is a different.
which is not at all applicable to him.
Oh.
Subsequently, he has
I
withdrawn.
can establish, your lordship.
Yes.
Your lordship, there was an assessment under the Entry Tax Act, your lordship. Pursuant to
So you
the-
want to move it now?
Yes, your lordship. If your lordship takes it up after lunch also.
No, it is up to your choice.
Yes, your lordship.
You wanted your senior to argue, that's why.
Since my learned senior submitted, that is why I was clarifying, your
Then
lordship.
I have not completed my.
Then
Your lordship may kindly.
come after
Turn to-
lunch.
Obliged, your lordship.
Excuse my lords, I know a matter is going on, so I won't disturb that hearing. That item number 3, subject to your lordships, if it can be taken up today after.
No, it says the last matter.
All right.
Your
Because
senior, your junior requested.
I know, because he was under the impression that the other matter will continue, but there is a
And,
division. bench.
your opponent is a formidable opponent.
I know.
He has taken a preliminary objection.
No, I'll.
And oh, your matter. So
That thing, item number 3.
Item number 3.
okay. Let us see.
Item 8. May I please, my lords?
Yes.
So this is a matter, I will like to take my lord's attention, my lords, to page 23, my lords. 23.
Yes.
Your lordship will find that the audit assessment, the genesis of audit assessment is the report, audit report. And your lordship will find that's the second paragraph, the interstate purchase of 2019 and import of 2019 do not take into consideration for the audit period as the audit period covers 2010 to 15. The import of rupees 3 crore 66 lakh 37,660, which occurred in 2009-10, the dealer submitted bill of lading is so and so and so. So this turnover relate to the period 9-10, and the assessment period for which bill assessment are taken, that pertains to 10 to 15 minutes. So this is excluded by the audit team, not to be covered by audit assessment. What has done, Milos, your lordship will find from page 32 for a while, my lords may kindly see. 32, my lords.
Yes.
Moreover, the dealer company is liable to pay entry tax of 1% taxable terms so and so on valued at, and insulation from glass valued at 3 crore 66 lakh 37,661 purchased in course of import outside India for the sale in course of, this is that figure, and that pertains to 9-10. Whereas
32M.
Whereas the assessment.
Mr. Sahu, which paragraph, which line?
I am
Where
placing.
does the audit team?
I am placing, Minos, page 32, middle paragraph. Moreover. Yes. Moreover, as the so and so valued at rupees 3 crore 66, a very same figure, purchased in course of import outside India for sale in course of execution works contract to contracting, namely so and so Paradeep, during the tax period 1/4/10 to 31/3/15. This is out and not correct because this is for 9-10. And your lordship will find at page 27 the period for which assessment undertaken mentioned from 1/4/10 to 31/3/2015.
That's true.
Yes.
That you have shown.
There are also some other connecting ancillary mistakes which has given rise to 7/5 interest because of this erroneous calculation of tax on a amount which is not pertinent for this period of assessment. So 7/5 interest is also proportionally reduced bills. But I filed a rectification application. Your lordship will find annexure 3 and also one additional rectification application that is filed annexure 4. In annexure 4 at page 42, your lordship will find from paragraph 1, the very same thing is clearly mentioned that 3 crore 66 pertain 9-10. Now what has happened? He has passed a rectification order, filed annexure 5. That rectification, your lordship will find without considering my Millard's very pertinent submission that the figure doesn't relate to the assessment period 10-15, it pertains 9-10, and without considering the other issues, Millards. What he did only on the issue that the period for which interest is calculated is for a larger period. He shortened the period. That's a mistake. I am rectifying this. That your lordship will find page 44 for a moment. My lords may kindly see. Moreover, in a subsequent petition filed on second paragraph, page 44. Subsequent petition filed on 21/17, the dealer company stated that against total ET dues of 11 lakhs so and so determined for the tax period 10-15, interest amount comes to 39 lakhs so and so has been determined taking into account delay period of 5,840 days from the due date of payment, that is 21/1/11, to the date of assessment dated 6/12/17, whereas the actual delay period 2185 days instead of 5840 days taken the assessment order of determination of interest accordingly modified. That resulted in reduction, Millards. But so far as the other issues are concerned, this is only so far as the days are concerned. But so far as quantum 7.5 is to impacted because lesser amount of tax is calculated. 9.10, which is the crux of the issue, pattern difference that has not been considered despite of Millards specific. Now, Millards, against this order, Millards, I carried Millards revision application. But if now I will take my lord's attention to position of what the law says.
Against the assessment order, you have filed a revision.
No, against the rectification order, I filed. Yes. Now I will bring to my lord's notice what is the position of law, whether I am correct or not, and what has happened. My lords may kindly say rectification provision under section 20 of the Indian Tax Act, Millards, for a moment. Section 20.
Two zero.
Minus. Caption, minus. 20.
Yes.
Rectification of mistakes.
Yes.
Caption. With a view to rectifying any mistake apparent to record, assessing of appeal authority or revision authority at any time within 5 years from the date of an order passed by amend such order. Now, you lordship may kindly skip all this. Kindly skip subsection 3, Millards. An order passed under subsection 1 shall be deemed to be an order under the same provision of law under which the original order, the mistake in which was rectified, has been passed.
Correct. Has to be.
Exactly, Millards. So that means the rectification order is nothing, but it has trappings of
is a mere correction of a mistake.
Absolutely correct.
Say the ministerial mistake. Nothing
Exactly,
more than
exactly. So therefore, the rectification order is nothing but an assessment order, Millards. And
So
once
against the assessment order, you have alternative remedy of appeal.
that is what, Millards. I understand. That is why I pointed out.
How could you maintain this revision?
Millards, what has happened? Your lordship, right? I have approached the wrong forum. And the wrong forum admitted and adjudicated, Millards. Even if he has no power, your lordship will find revision power, which is there. I understand, Millards. Let me tell the truth, Millards.
No,
I approached the wrong forum.
No, have you filed appeal?
Sorry? No.
Appeal.
I filed a revision instead of filing appeal.
So after revision, have you filed any appeal against the assessment order?
No.
I for section 23.
No. I filed a revision, and the revision authority, Millards, had decided the revision application. Because against that order, again I filed the revision before the Commission of Commercial Taxes. And what else? Just a minute. Commission of Commercial Taxes. And there are two, one under the OIT Act, under the VAT Act, Millards. Under the VAT Act, Commissioner also decided the second revision petition, which he has no power to do. And after that, I discovered, Millards, when normally, Millards, after the client approaches the lawyer, after going through, I find it's a wrong forum. And not only wrong forum, the authority concerned and again the commissioner, they have all exercise power which is not vested under law. Orders are in nullity, Millards. So, Millards, we advised in this case to withdraw the revision before the commissioner. We have withdrawn. I have filed the application, which is also in the matter of record. So, we withdrew further revision before the commissioner to approach your lordship. Now, the operative order is the wrong forum's order, the revision order before lordship. I know section 29 to read with section 14 is very clear. If wrong forum is there are judgments also, Punjab, Haryana, and all judgments Supreme Court.
Sir, instead of coming here, you should have filed appeal there.
I only pray for relegating me there. That is my only prayer, Millards. Nothing more.
2017 order.
Only that's my prayer.
limit within which
No, outer limit is not
is
there.
not there. So
There is no outer
you
limit. Proviso is there.
you can exhaust your remedy because there is no outer limit which is provided there for condonation. So you can take advantage of section 14 of the.
Millers, for appeal, there is limitation. You might not know.
Every appeal has a limitation, but power to condone is not brindled by any outer cap.
Correct. Yes, yes.
So it's an unlimited, it can be condoned for infinite period of delay. There is no difficulty. If outer cap is given beyond that, it cannot, then I can understand that you have some problem.
Millers, under these exigencies, these exigencies, your lordship have also relegated one matter very recently. And just a minute. And Punjab and Haryana High Court Millers, identical issue Millers, while observing all these facts. That's
Why should we make any observation with regard to section 14? You have every possibility there. You
No, no.
first apply-
relegate, I will file condonation application. That will be decided. Yes.
We are not relegating. We simply say we refuse to exercise our judicial review power because of the availability of alternative efficacious remedy. That's all.
Only background, unless your lordship does briefly say so, because your lordship knows I am at a stage after existing so many remedies, because I will go back once again to appellate forum. So unless your lordship, because that many 192 section 14 all that, but at least by relegating and allowing me to file that, they will consider
the wrong forum or what we will. These are the observations of the High Court that we are not going to do this.
My lords.
Simply say the alternative remedy. That's all. Is a discretionary one, and we refuse to exercise the discretion.
Actually, pendency may be considered.
Pendency from
Pendency
2025.
before this on, before the commissioner.
That you can take. That you can take.
From the
That
beginning,
you can take.
from 2000s.
Only liberty to mirrors back all submission
liberty.
there. They will consider. Only your lordship kind of observe because all court of Punjab, Haryana, I will show to your lordship. Gujarat also mirrors. That is affirmed by Supreme Court. On this situation.
Let us confine to this court, sir. What the others have done.
I understand. Court said if conditions of section 40 satisfied and court finds this is so.
You satisfy the authority.
I will be not.
Not-
Only I want to, only.
Not a single provision is applicable what he has adopted. What are the forum adopted? Your lordship.
Why we will enter into
Your
those
lordship.
errors?
That's your lordship decision kindly. Just identical matter. How the approach
Copy.
should be, a lenient approach. Yes.
Copy.
So,
No.
your lordship
Here
very
it is
nicely.
different.
That's
Here it is
precisely
different.
and
Your-
nicely. Your lordship have said how the forum should deal with. Very precisely and very nicely. Your lordship have couched the order.
No, that is in relation to a consideration of section 5.
I know.
We are not considering section 5.
This is for 14. Yes.
You can utilize this judgment there before the authority, but it is not a case here.
Anyway, I leave to your lordship to briefly speak something so that that will come to my rescue at least. Fine.
The petitioner has approached this court under Article 226 of the Constitution of India, assailing several orders passed by the assessing officer and subsequently by the revisional authority.
Revision order. Yes.
Raising multiple issues, including that the authorities have proceeded with a closed mind without adverting to the issues involved in those proceedings. Stop. The sum and substance of the the contention as raised before us admits no ambiguity that the real purpose is to assail the order of the assessing officer, for which an alternative remedy by way of a statutory appeal is provided to the petitioner. We are not unmindful of the proposition of law that mere existence of an alternative statutory remedy does not absolve the High Court in entertaining the writ petitions in pursuit of a judicial review, but a self-restraint has been imposed in this regard, and the High Court may at times refuse to exercise such jurisdiction. The High Court may refuse to exercise such discretion vested under Article 226 if it finds that the points raised in the writ petition can be conveniently raised before the statutory authority, and no fetter is put on the part of the statutory authority to decide this. Solely on the ground that the petitioner has an alternative efficacious remedy provided in the statute, we refuse to exercise our discretion. Stop. It is open to the petitioner to ventilate his grievance before the statutory authority in accordance with law. The writ petition is dispensed.
Get that's a original order.
Consciously, we have not said anything on.
Your Lordship. Sure. For that reason, I have not mentioned.
Item 9.
Here, this is under the CGST Act to challenge the so-called notice issued under Section 74. Here, after audit, kindly have a glance to Annexure 2, that is audit 82.2 at serial number 11. Splitted the demand and issue multiple so-called notice to overcome the monetary limit. As per the circular, there is a limit for superintendent and assistant commissioner.
So it's a clubbing of the several assessment years into one so-called notice.
That multiple year is there. And apart from that, multiple, kindly have a glance to read petition page 7.
Where is the earlier decision, Mr. Kedia?
Your Lordship.
Is there any earlier decision?
Already similar matter has been admitted.
Pratik still
Appears to be a covered matter,
Still pending.
Still pending.
but appears to be a covered matter. What
Yeah.
order has been passed?
Your Lordship.
Here,
When the other matters are coming?
this is not splitting of, this is the multiple year, another.
Multiple
This is the multiple year. There's 3 issues there and 3 issues already admitted in 3 cases, but here all are clubbed in same so-called notice. And this is the 74. That is, the ingredients is not satisfied.
What has happened thereafter? 5th November?
It is not listed, my lord.
5th May it was directed to minister.
No, the authority had no, has no power to go in for 74 assessment.
Yes, that is
Yeah.
also, that is ingredient is not satisfied.
This Taraknath Das case.
Yes,
you're citing.
74 ingredient not satisfied.
Oh.
Because it is
Ingredients
outcome
of-
from the audit,
Ingredients of
74.
74. Fraud misrepresentation
Yes,
is
fraud.
not there.
This is the clubbing of the several financial years into one so-called notice.
No, that is not correct.
No, he is saying.
Clubbing is also 3 issues there.
But your lordship, in this case, audit has been done. In audit rule 101 says, and the period of audit can be conducted for under section 65(1) for the financial year or part thereof or multiple thereof. If multiple thereof,
That's
years.
financial year.
So other financial year. So in that case, multiple notice can be served, your lordship.
In the
This is
meantime,
an
man,
audit. This is an
Kerala.
audit.
How many years you can take up audit at one go?
They generally, in this case, they have taken for
Restricted,
5
yeah.
years, your lordship.
Or how many tax periods you can take up audit at one go? How will you be ready for your audit?
There is a time limit, your lordship, to.
So for 15 years at one go you can do.
Generally,
He
they are
he should be ready with all
Yes.
books of account.
Generally, are taking for 5 years.
So how will you say? How can you say?
Uh,
So each year limitation starts. If you club up 7, 8 years, then first year, from which date you will count the limitation period?
Generally, it's a very difficult for an SSC also,
Please,
your lordship,
please.
but.
And apart from that,
as-
financial model is there for filing the appeal. I have to, at a go, I have to deposit 10%, that will be also a huge amount.
So if you club together and then one composite demand is made, then the difficulty is because each financial year that constitute a independent.
Recently, Kerala High Court has also finally one.
How can you do that?
In all these different issues of audit, they have issued a separate notice for RCM on director remuneration. They have issued a separate notice for
Issue wise, they have
RCM on legal expenses. They have issued a
So all
separate
have to
notice
be clubbed
as
up
per audit.
in one year. The transactions pertaining to a year, it would be easier for the
I agree with
taxable
you, but
person to comply your notice. And he can keep his books of account ready and other documents ready for you to audit.
for that, lordship, for that year.
Can you also do an audit for 15 years or 7 years, voluminous books of account to verify? Is it not cumbersome for you? Same thing happened to VAT also.
Yeah, lordship.
In VAT statute, one of the judgments of this court may not be judgment, one of the orders are there. This court, the multiple tax periods can be taken up. But that is under different context.
The confusion is still there, period or.
Under VAT, this court in a division bench held that multiple years, or it can spill over to more than 1 year.
ନାଇଁ ଗୋଟେ କପି ଥିଲା ସିଙ୍ଗଲ ବେଷ୍ଟ ଅଛି ଦେଇଦେ ସେଟା ସିଙ୍ଗଲ ଗୋଟେ କପି ଆଣିଥିଲି ସେଟା ଦେଇଦେବି ତତେ ଆଉ ଦେଖ ଏଇଟା division bench overloads. No, I'm not a part of this. দিয়েছিল এক করে দিয়েছি এটা দিলি বা এটা দিলি এটা নেই আগে দিয়েছি তিনটা দিলি যে আমার হাইকোর্টে অচল করে শীঘ্র আছে সেটা দেখুন তার আপনার
Is very clear. What my brother says is what has been. That for one particular financial year, there may be a limitation which has intervened and expires, and then you have revived. This cannot be done. Yes, I think you are entitled to a notice. And
We'll take instruction.
what is? The other matters are to be heard along with that.
Yeah, along with that.
Yes. Possible.
Proceeding to state. This proceeding is, I am challenging the so-called notice.
So your bona fide? As on technical ground, show your bona fide.
Yeah.
How much?
What is the proposed demand? Or they have not?
Proposing 46,
46 lakhs and not.
including interest and penalty. It is page 7. And out of that, I have 10 lakhs already have paid.
You already paid. So the remaining is 36.
Notice if there are 3 appeals, one is.
Let us go conservatively. 36 is there. How much? Something is to be put. You go to the post.
No demand.
Yeah?
No demand.
There is no demand as of now. There is a demand.
No. I have
These
challenged
are so
so-called
they have
notice.
challenged to the so-called
So-called
notice.
notice. This is proposed demand.
See, it will remain under suspension. That will remain under suspension. So that the limitation can be corrected.
Financial years. Second review, 18, 19, 19, 20, 20, 21, 21, 22, 22, 20.
Page 22,
Page-
Lordship.
Page number,
Page 22 of the so-called notice.
notice it's sale.
Counter? 2 weeks?
3 weeks, Lordship.
3 weeks. No, by 5th, because this matter is coming up on 5th.
5th. Multiple is coming on 5th.
Written there. You file in one, that will cover all.
And notice there are.
Counter, you file in one, that will
To
cover.
get.
There are other counsels.
So you can adopt the counter and serve it on other.
it will be difficult within a short period to get that. But we'll get paravise comment, it take time from the department. That is the only reason. On the 5th, it may be fixed up, we'll take care of then.
Yes, if you do not get anything, we'll accept it, don't worry. But come on, Faith.
Other two are for the other issue, same.
Same.
Comment. Item number 10.
Item number, may I please, Lord, sir. Item number 10 is relate to RC
Cancellation
cancellation.
of a certificate, give. Yes, have you checked?
Yes, sir. Lord, sir.
Yes.
Item 11.
180 meters, my Lord, sir.
Short lifting,
180 ml.
180 ml.
अब कितने
Item 12.
May I please, your lordships. May I please, your lordships. Lordships, in this matter, the petitioner is having its business, parent business at
Which one?
Jharkhand.
12 May.
The petitioner is having its parent business at Jharkhand state, your lordship. And pursuant to that address of the petitioner, your lordship, kindly have a glance at page 62, annexure 7, your lordship. Page 62, annexure 7.
Yes.
As per Income Tax Department data, your lordship, the address of the petitioner is reflected, that is at Jharkhand, your lordship.
Yes.
In the year 2022, your lordship, this petitioner came to state of Odisha for business, and the registration certificate is at page 72, your lordship. Registration certificate of under GST Act, your lordship, in Odisha state, your lordship, that is at page 72.
Yes. Yes.
This is the address reflected in the address of principal place of business, your lordship. At point number 5, the address is reflected.
Yes.
On a fine morning, your lordship, the petitioner received a recovery notice. Actually, he has not received the recovery notice. He's got the information from the bank that entire bank, all the bank accounts have been attached because he was declared as defaulter by the service tax department, your lordship. And he approached the department from which the service tax authority in the Odisha state, your lordship, and that is at page 60, your lordship.
Is this notice?
Yeah, at page 60, your lordship.
Uploaded.
No, your lordship. In service.
Web portal, it was not.
No, your lordship. At page 60, your lordship, when he approached the authority on that particular day, 28/3/2025, he was served with that particular recovery notice what was sent to the bank authorities. And he was served with that particular recovery notice, that is at page 61, that is at page 58, your lordship, the recovery notice. 19/3/2025.
Yes.
The authority served that recovery notice to the petitioner on the date 28/3/2025. And pursuant to which he filed on the same date, he filed his reply, that is at page 60, your lordship.
Yes.
Saying that, may I place that, the reply?
You say that you did not work during that particular relevant period in Odisha and therefore the.
Never, he was never an assessee under the Service Tax Act in Odisha under his jurisdiction of this authority, Your Lordship. And also entire.
What about page 61, which you have included?
Yes,
in Annexure
uh,
6?
and page 61, the authority provided me the entire order and the demand cum so cause notice, whatever on what basis the recovery notice was issued, that was supplied to me on that particular date, and that is the acknowledgement given by the authority himself.
Your advocate and authorized representatives have
Again, yes.
acknowledged it.
No, you let's say left side. Acknowledgement receipt.
Huh. Your advocates.
Yes, let's say.
So
So
you have
it is
notice, you get the opportunity.
no, you let's see. Never.
Yes.
It was reflected in that acknowledgement receipt, you let's
He
see.
says that he appeared in the office of the superintendent GST.
28/3/2025, you let's see. On that date, he was served with that order in origin. It was accepted in the second paragraph, you let's see. He has appeared in the office of the superintendent GST and Central Excise, Rourkela to range office, and accordingly received the order in original such and such dated 3/7/2024, original copy, because it was not served. Issued by the Commissioner GST Central Excise such and such dated 3/7/2024.
So you did not furnish to the department your correct address. You
No.
have given insufficient
Your
address.
Lordship, kindly have a glance. The order in original that was supplied to me on that date, the address is completely different.
What
And
different?
Your Lordship,
That's the Jharkhand.
yes,
That is your registered with your.
no,
it is-
in
did not-
Odisha,
While shifting, you did not intimate them.
Your Lordship, in Odisha also I have shown Your Lordship, that is page 72. My address is there.
Yes, that we know. You are showing it that it is address where.
Yes, RC, Your Lordship. In GST era, I came to Odisha in
Jarekala address from where they have got? Jarekala address.
only the department council can say, Lordship.
That instruction.
In the registration certificate, some other address was there. And 26 years
Some other
Jharkhand
Jharkhand
address.
address.
But in your demand come show cause notice, some other address, you wanted to serve on that address,
My lord.
which she never disclosed it to you.
That is also Lordship service
So
check.
that is why in 2025.
Well.
So why you have said that it is insufficient address?
We have tried
How could you
to,
say that?
we have tried to deliver in that address, but the
Which address? How could you, your demand?
Jaraikala address, only one thing.
Jarekala Bandamunda,
My lord,
that was never disclosed.
my lord, only one thing I have to ascertain from the department, from where they have got that address.
But
Give them an opportunity
But-
to take it.
but when the
Prima facie, my lord and sister having a case here over here.
You should.
I'll just ascertain from the department regarding the that address.
Only case is service of notice.
since March, mid of March, my account has been freezed. And the petitioner has to pay for the
Your
latches of the
lordship may
department,
grant-
Your Lordship,
your
because
lordship
I was never.
Get the instruction by 29th or 30th.
29th is not possible. Your lordship may grant.
30th you come. That's possible.
As your lordship.
Come on 30th
Obliged.
to take instruction.
Item 13. May I please, your lordship?
Vizag photos. P5. Yes. What has happened? Now the girl is rescued.
Your
What of the
lordship.
matter?
Still not rescued, your lordship.
Oh, this is another.